to Probate and Family Court. I submit this nomination for advice and consent of the Executive Council pursuant to Part 2, Chapter 2 of the Constitution of the Commonwealth of Massachusetts. I'm enclosing the nominee's resume for your convenience. Good morning.
Hey.
So before we get going, if you'd like to introduce any of the folks you brought with you, you
Sure.
can take that moment to do so.
Thank you. This is my husband, Dave Callahan, my stepdaughter, Desiree, my very good friend, Dave Benzani, who is an attorney in Rhode Island, my partner, Irina Inman, my partner and one of my witnesses, Delia Bonney, my very good friend, Andrew Zawada, and my very good colleague, Bryn Zawada, who is also one of my witnesses.
Excellent. So
Chief Justice, your boss.
This is Chief Justice Casey, and I am so thankful that he's here today.
it's pretty important.
Take it. You would have been sitting out in Pittsfield.
Thanks. So we're gonna hear first from your witnesses, and then you'll get a chance to offer your statement. So I don't know what order you're going in, but you can.
Delia, you're it.
Good morning.
Morning. Good morning. My name is Dalia Bonzani. I'm honored to be here today to speak on behalf of Attorney Laurel Barraco in support of her nomination for the position of Associate Justice to the Probate and Family Court. Laurel is my current law partner at Callahan, Barraco, Inman, and Bonzani, and my very good friend. I first met Laurel 12 years ago when she was hired at a law firm where I had only been working for about a year. I was immediately impressed with her confidence, intelligence, and sense of humor. Laurel soon became my supervisor within the office. To be honest, when I first learned that she would be my supervisor, I was not so thrilled because Laurel and I graduated law school around the same time and had similar levels of experience. However, I soon realized why she was tasked to supervise other attorneys, even ones who had been in practice for longer than her. She took the time to check in with her attorneys, talk about difficult issues they were having with their cases or clients, and gave useful feedback to work through those issues, all while managing her own caseload. Laurel and I worked together at that firm from 2012 until 2016. Then in 2016, she and attorney David Callahan, her now husband, left the firm to start their own. I'll never forget Laurel calling me from the parking lot after walking out of that office for the last time and asking me to join them. The date was March 17, 2016. It was St. Patrick's Day, and it was 4 days after the birth of my first child. Anyone who knows me likely knows that I don't make big decisions lightly. But when Laurel called me, I immediately said yes. I wasn't worried about money or job security, especially after just having birth. I just knew that if Laurel was behind it, and it was something that I wanted to be a part of. Turns out it was one of the best decisions I ever made. I joined Callahan Barraco when there were only 4 attorneys and 2 support staff. I witnessed Laurel build the firm from the ground up, helping it to make it into one of the biggest, largest, primarily family law firms in the state. Laurel is always searching for ways to grow herself and her team personally and professionally. When the firm first started, Laurel educated herself on how to maintain happy employees so that they would be proud of where they worked. Laurel wanted to make sure her employees felt respected and valued, and I believe that she will show the same respect to anyone who works alongside her or comes before her in her courtroom. Laurel takes a lot of pride in the reputation our firm has built in the legal community. She personally has garnered an excellent reputation amongst peers, judges, and clients. She is known as a reasonable and collaborative opposing counsel, but a fierce advocate. I have witnessed times when some attorneys initially doubted her or saw her petite stature and assumed that she would be easy to push over, only to quickly stand corrected. Laurel earns the respect of everyone who works with her due to her intelligence and affability. I believe these qualities will serve her very well as a judge. Laurel is one of the first people I turn to for advice or when I need someone to talk to after a bad day. As many people know, family law can be a very emotionally charged field. While Laurel no doubt has dealt with her own share of emotionally charged cases and clients, she has a natural ability to remain calm and composed under pressure, even through the most difficult times. This was especially evident when Laurel was diagnosed with breast cancer at age 30. I witnessed Laurel fight the disease with bravery, grace, and optimism before returning to work with a stronger dedication to her practice and her clients. When Laurel told me she was considering applying to be a judge, I knew that she would be a strong candidate. About a month ago, Laurel met with Governor Maura Healey. She called me after the meeting and I asked about their conversation. She told me that Governor Healey asked her, "Why do you want to do this?" To which Laurel responded, "Because I think I would be good at it and I have something to give." I truly believe in Laurel the way she believes in herself. Laurel would be an excellent judge and she has a lot to give. Thank you for your time.
Thank you for that statement. Are there any counselors who have any questions for the witness?
Thank you.
Thank you.
Thank you very much for coming in.
Morning, counselors.
Morning.
My name is Bryn Sawada, and I am a solo practitioner with a firm in Worcester. I've been in practice, practicing exclusively in family law since 2011. I first met Laurel in 2018 as opposing counsel on a custody case. I distinctly remember meeting Laurel for the first time. She was practical, knowledgeable, and bubbly, but not in an annoying way. I liked her instantly. Our case was complex. There were allegations of domestic violence against my client, the father. There were issues with restraining orders. There was a parenting coordinator. There was a guardian ad litem that was appointed. Laurel's client was challenging. Laurel was the third attorney that was representing this particular individual. And it became evident as the case progressed that the allegations that were raised by the mother were unfounded, and that she was undergoing or going through some mental health issues of her own, which were exacerbated with COVID, which hit throughout the middle of the proceedings. I was impressed with Laurel's ability to maintain her demeanor and represent her client in difficult situation. I recall a deposition that I was doing with the mother where I introduced documents that specifically discredited statements that mother had made under oath. Despite being caught off guard, Laurel maintained her demeanor. She stayed calm, cool, and collected, and she was able to advocate for her client in an admirable way, always treating her with kindness, compassion, and respect. Over the years, I've had an opportunity to work with Laurel on several other cases in various roles, including as a conciliator and as an ARC counsel. I have had experiences and been able to observe her interact with other individuals, pro se litigants in the halls of the courthouse, opposing counsel and parties, and as well in hearings in front of the judges. Laurel is always prepared and she's always respectful. When I was preparing for today and thinking about the traits and what traits make a good judge, there were two that kind of came to mind. Compassion. I think the work that we do as family law attorneys is incredibly challenging. We interact with individuals on a regular basis who are often at the lowest points in their life. These are individuals that have struggled with trauma, whether that's from physical, emotional, or financial abuse, individuals that are struggling with mental health crises, and some that are dealing with substance abuse issues. And I think it's of paramount importance for a judge to be able to maintain a sympathetic attitude and have a desire to help these individuals. Laurel is one of the most compassionate people that I know. There are so many observations that I've made of her looking for ways to help others, whether it's offering a compliment to a random stranger on the street or approaching pro se litigants who clearly are struggling and don't know what they're doing in the courthouse halls, offering advice. When Judge Stark, who sits in the infamous courtroom number 9 at the Worcester Probate Court, announced her desire to implement several blitz sessions of conciliation to try to address the backlog in that case, in that courtroom, Laurel was one of the first to volunteer. She, when she found out that there was a significant shortage for the Lawyer for the Day program of attorneys that were willing to participate, she committed to monthly, multiple sessions with phone calls and meetings with individuals looking for help. She also volunteers as an ARC counsel, representing the interests of minor children in contested custody and divorce cases. The second trait that came to mind is humility. I think it's important for judges to maintain a sense of humility from the bench. Laurel is incredibly smart. She's an amazing and an invaluable resource as a sounding board, often always willing to lend an ear and offer advice. She mentors young attorneys that are just starting off, and she's always the first to admit when she doesn't know the answer to something or she needs help. These traits and many others I think Laurel possesses will make her an invaluable asset to the judicial branch if you nominate and vote her through next week. Thank you for your time and consideration.
Thank you very much. Do any counselors have questions? Yeah, Counselor Kennedy.
Glad I don't do probate work. Give me our presentation and without looking at notes how well you did it, I'd be losing all the time. Appreciate your comments.
Thank you.
Thank you, Counselor. I have a question. Not often we have so many people from Central Mass in the room, so that's exciting. You used the term infamous courtroom number 9.
Yes.
Why is courtroom 9 infamous in the Worcester courthouse?
Courtroom number 9 has had influx of judges that have served a rotating role over the past couple of years, which makes it incredibly challenging as a practicing attorney to maintain consistency throughout cases, and also just the uncertainty in trying to explain what judge is going to be hearing your case and how this judge expects.
What do you mean by inconsistency when the judges are rotating?
Every week, sometimes there's been some, so the consistency has slowed down a bit with Judge Stark. So Judge Stark has been sitting in that courtroom for a while. She's lovely. We all really appreciate having her there. But there was a period of time where every day there was a different judge. There was like a 3 rotation of judges that were kind of filling in. And it's hard because cases get continued. There's sometimes some stagnancy in the progress.
Yeah, and as you're noting, it's hard for a judge to get up to speed on everything that's going on. Okay.
So Judge Stark made a big difference when she kind of implemented and had a couple conciliation sessions, which I think really assisted parties in being able to move their cases.
I was proud to vote for Judge Stark, and she's doing an excellent job according to every single person I talked to. You know, she's a resident of Counselor Jacobs' district over in East Hampton. And I know that we're struggling in all our courts to balance the needs. And I know that we've added a lot of probate judges in terms of seats that we continue to fill. And so I'm so happy to see someone from the region who might end up sitting in Worcester consistently. And I know across probate, juvenile, superior, we're hurting for getting some of our experienced, qualified, respected attorneys on the bench. So thank you for sharing that. I was curious about.
Thank you for all of your work.
what goes on.
Very much appreciated.
Thank you very much. Appreciate your testimony.
Application.
Oh, well, thank you.
Okay, so first I'll ask if there's anyone here to speak in opposition. There being none. No, she was curious. There being none, I just want to take a moment to introduce the counselors. Counselor Chris Iannella is ill today, unfortunately. Counselor Ziegler is joining us remotely this morning. Good morning. Counselor Terry Kennedy, Counselor Tara Jacobs, Counselor Joe Ferreira is in traffic on his way up from Somerset, but I think we're going to see him. Counselor Civil, Counselor Dolan. And with that, I understand you have a concise statement to offer, and I know the council is eager to hear it, so please go.
Thank you. Good morning, Mr. Chairman, distinguished members of the Governor's Council. I am honored to appear before you as a nominee for Associate Justice of the Massachusetts Probate and Family Court. I'd like to express my sincere gratitude to Governor Healy for nominating me and Lieutenant Governor Driscoll for her support of my nomination, and to the JNC for their tireless and important work in screening and evaluating candidates, and to the Governor's Office, including Valerie McCarthy, Chief Legal Counsel Scott Reed, and Deputy Legal Counsel Derek Hesselheim for your time and energy. Thank you so much. Last but certainly not least, I'd like to thank again Chief Justice Casey for his support, as well as several other justices who encouraged and guided me in this process, including Judge Tierney, Judge German, Amelia, Judge Bailey, and Judge Ordonez. Thank you. Also, thank you so much to my friends and family who are here and who are not here. I could not be here without them. With that, I'd like to take a few minutes this morning to tell you who I am and what experiences in my life have led me to this day. I was born and raised on Long Island in New York. Before you judge me for that, please know that I grew up a Mets fan and a devout Yankee hater. And if you follow baseball, you know that being a Mets fan has taught me how to endure all forms of pain. My mother was an RN and worked long hours on the surgical open heart team, and my father was and still is a professional touring musician. I did not grow up wealthy, but my childhood was rich in love, support, laughter, music, and happiness. My younger brother and I were lucky to experience a truly whimsical childhood, complete with shoeless summer days, big family trips to the beach, bicycle rides, and cookouts. When I was around 10 years old, my parents divorced and my father moved out of our home. To this day, I don't know the details of my parents' divorce, and I consider this to be a great credit to them. I don't recall any fighting, animosity, or blame, or ever being put in the middle of a great emotional fight. Life went on as usual. just as loving, just as supportive, but in two different homes. Looking back now, I'm sure that my parents struggled through this time, but outwardly, they were a united front for my brother and I, continuing to co-parent together and continuing to sit together at our school functions and games and endeavoring to be a joint presence in our lives, even continuing to this day to celebrate holidays together with us and our families. My parents' ability to put whatever differences they may have had aside and focus jointly on my brother and I has been one of the greatest gifts my parents have given me. I knew from a young age that my parents' divorce would play a role in my life and career. And by the time I was a teenager, I was determined to go to law school and eventually become a family law practitioner. My parents weren't the only influence guiding me towards this career. My mother is one of 9 children, and I'm close with my large family, especially my Uncle Steve, one of my mother's older brothers. Uncle Steve lived with my family when I was a toddler, and as long as I can remember, my uncle's partner, now husband, Uncle Wayne, has been in my life. I spent my elementary school and middle school years watching my Uncle Wayne study for the LSATs, and then midterms and finals in law school, and then the bar exams, and eventually build his own very successful family law practice. For many years, every holiday and family get-together, Uncle Wayne would hide in my bedroom studying, only making an appearance to eat or open presents on holidays. And in my insane juvenile brain, I thought to myself, yes, this is the life for me. I want to be just like my Uncle Wayne, and I had no idea how true that thought would become. Within a few months after graduating from law school, I began practicing family law exclusively and have ever since. I was a young attorney and really felt on top of the world. I found that I strongly identified with this area of law and felt I was able to make a real difference in the lives of so many going through their most difficult times. I was completely shocked when at the age of 30, my career had to be put on hold and I was diagnosed with an aggressive form of breast cancer. Upon receiving my diagnosis, I resolved to continue practice through treatment. I was so very wrong. I had so much to learn from this experience. One of my first phone calls was to my Uncle Wayne, who had also been diagnosed with cancer a few years before me, and who had also gone through chemotherapy, surgery, and radiation, just as I was about to do. I really do everything my Uncle Wayne does. He assured me that I would have a long career ahead, and maybe my work as an attorney would have to take a backseat to my health for just a little while. With that, I began treatments, and life changed drastically. I traded in my trendy pantsuits and heels for oversized hospital Johnnies. I lost a lot of weight and all of my hair, and I was really sick. It was during this time that I could not care for or help myself that I surrendered to those who could, and I'm incredibly grateful that I did. I learned a lot of lessons during this period of time about myself and my ability to make hard decisions and endure difficult things, but I also learned a lot about the people of this Commonwealth and saw the best that humanity has to offer through this trying time. When I was weak, sick, and broken, and when I needed the most care and compassion, I received it from complete strangers. Not just the incredible doctors and nurses at UMass, where I received the highest level of care, but from the valet parking attendant who took me by the arm and walked me into the emergency room and waited with me until a nurse took me in to make sure I would be okay. And the old man who volunteered on the infusion floor and always gave me a turkey sandwich along with a joke to make me smile when I didn't want to. And the hairdresser who, when I asked for a very short haircut in the anticipation of losing my hair, didn't charge me a dime. And the elderly woman with the thickest Boston accent I've ever heard, who fit me for a wig, and she tried to make me go blonde because they have more fun. She made me belly laugh through my tears. The number of the amazingly empathetic people in this Commonwealth who changed my life during that time is too long to list here, but their lessons stay with me. In 2016, with a G.I. Jane haircut and a clean bill of health, I started my family law firm with my partner and eventual husband, David. My husband, who's here today, has 3 children, my stepchildren from his first marriage. All 3 of these incredible children were adopted from the Department of Children and Families Care by him and his first wife. When I met these children, they were 6, 8, and 10 years old, and their emotions were raw from the recent divorce of their parents. Each child dealt with their feelings very differently, and I had a unique opportunity to witness my husband and the children's mother navigate this co-parenting challenge. I've been privileged to support the co-parenting relationship and assist my stepchildren in becoming kind and productive emerging adults. In addition to my stepchildren, my husband and I welcomed our son Charlie to the world in 2021. He's now 3. The responsibility, fear, guilt, joy, and unconditional love that one feels as a parent can be overwhelming. I completely understand why family law can be so emotional. Our children are our most precious assets and must be protected at all costs. Throughout my life and career, I've learned how important having a mentor can be. I'm proud to foster and guide young attorneys and have grown my firm from 2 to 20 attorneys in an 8-year span. I try to be a mentor to all the attorneys at my firm and encourage all to become involved in pro bono practice and donate their time to bar association committees and other worthy causes. While I'm not a native Bay Stater, this is my home. And this is the place that educated me. And this is where I was cared for, body and spirit, by complete strangers during my most trying time. This place wrapped its arms around me and showed me the best it has to offer: empathy, kindness, love, inclusion, and a life I could not have imagined. I know I have the grit and compassion and the temperament to take on this difficult task. I want the opportunity to help the most people that I can and to assist families and children in crisis. Thank you.
Thank you very much. We're now at the stage where any counselors who have questions, we have a practice of going in order by district. So since I represent District 7, we're going to start with Counselor Jacobs from District 8.
Thank you. Good morning.
Good morning.
It's good to see you again.
Yes, you as well.
I think our double meetings probably will stay in my memory for a very long time. But it's good to see you.
Yes.
Let's start with really basic. Why do you want to be a judge? Why do you want to be a judge in the probate and family court? And why now specifically do you feel you're ready?
Sure. Thank you for that question. Obviously, it's the most important one, I think. I strongly identify with family law. Just my life history, I'm a product of divorce. I've assisted my husband and his ex-wife in raising their children and co-parenting, and I have very strong feelings about how to protect children, that they need to be protected. And I really have the ability and the energy to help. I have found that throughout my practice that I've really loved transitioning from a full-time litigator to doing more pro bono work, lawyer of the day work, representing children, even conciliations. And I've found that I have the ability to come up with creative solutions to help families who are in need. And I think that's an important quality to have. The reason that I'm looking to transition from litigator to judge at this point in my life is it felt like it was a time in my life where natural progression should begin. I'm young, I have the energy to do it. This is my 10-year cancer-free anniversary. I felt that I have something big to give, and I'd like to start giving it for as long as I can do that.
I appreciate that. I'm going to segue from what you just said into another area that I think we talked about briefly. There's so many so fast that I'm not sure if we did or not, but the concept of family is one I've been giving a lot of thought to, considering we do have a bunch of probate and family court nominees coming all together. And I wanted to hear you talk about how you define family, and in an age when what that looks like seems to be rapidly evolving, what role you think the family court could play when non-traditional families break apart and there's children involved.
We did speak briefly about.
Okay, sure.
Thank you for that question. I think that nature of the evolving family and the definition is huge right now, and incredibly important to the family court. I don't think that there is a definition or one definition of family. I think that it is an antiquated view to say female mother, male father, 2.5 children. We see as practitioners all forms of family, same-sex marriages with children, polyamorous families, transgender families. We see it all, and I feel strongly that whatever rendition of family is before the court, they need to be treated the same respect, the same considerations given, and the case law applied to each individual family based on that family's needs. I think the court's role is to be a pillar for the community and ensure that whatever definition of family comes before them, they are treated with empathy, kindness, and listened to, regardless of what that looks like.
I appreciate that. So the area of access to justice is an important one to me. So I wanted to hear from you your thoughts around specifically the probate and family court, from your experience, where increased access to justice changes or evolutions have already happened, and where you think more work could still be brought into probate and family court. I don't even want to lead you necessarily, but one of the things I've been thinking a lot about is the self-represented proportion in probate and family. So I wanted to hear your thoughts around it.
Thank you for that. It's absolutely an issue in all of the counties. There is a large percentage of self-represented litigants, and access to justice. I would say that there's been a lot of work done by Judge Casey and his office in the past few years that have increased the access to justice. But I do think that still more work can be done. I think the Lawyer of the Day program in every county is very helpful. I think it can certainly be improved. I think that there needs to be more awareness for the program so attorneys can become involved. I genuinely think that attorneys do want to help, and a lot of them are not even aware of these programs that they can become involved in. I'd like to see a bigger partnership between the courts or the registry and different types of pro bono organizations, whether that be community legal aid or the Lawyer of the Day program or what have you, to be able to bring more attorneys in and help those who can't afford attorneys with getting their papers filed or just general legal advice. I think that another area where the court could bolster access to justice would just be more resources. And I'm aware there was an article that just came out a couple weeks ago in Mass Lawyers Weekly about all the great resources that the courts are getting, and that's very exciting. I think the court could certainly use more translators and more registry staff to help pro se litigants.
No, I appreciate that. When we think about some of the things you just talked about, Lawyer for a Day, legal aid, when there is imbalance between parties, one has more access to funds, is well represented, the other scrambling to just either self-represent or just try to find a way to be able to afford to represent themselves, but because of the financial family status doesn't qualify maybe for community legal aid income level, or isn't able to really, I don't know if the word compete is right, but self-represent at the same level as the other represented side through just Lawyer for a Day kind of advice and that resource. What are your thoughts around possible solutions to increase the equity balance when there's that kind of financial disparity going on between a couple in a divorce?
It's a great question. Thank you for that. And I do know that that's been a topic of interest lately. There are certainly measures that the court can take to attempt to equalize the disparity. any litigant can file a motion for attorney's fees, whether that be in a custody case, a 209C action, or a divorce case. Really, it's up to the court to look at the financial picture of both parties and determine if there are assets from which to take money for the attorney's fees. I know that when a party is represented by an attorney, there better results for the family, for the children, and I've seen firsthand how that inequity can play out. I would always look to try to equalize the amount spent on attorney's fees through joint funds, if that's possible. Sometimes it's not, and I obviously wouldn't be able to provide legal advice from the bench, but I could certainly provide knowledge and resources for where self-represented litigants could go to find some very costly representation, or perhaps pro bono representation.
So the last question I'll ask you is just, I'm interested in understanding how from the bench you might manage a situation where you have, let's say there are two represented, not two represented parties, and from your perspective, the lawyers themselves are increasing the contentiousness of the situation. What, if anything, would you be able to do from the bench?
Thank you for that question. Thankfully, I don't see that too often, but it certainly happens. I think that the most successful judges that I have seen deal with that situation do tend to call sidebars and speak directly with the attorneys. I obviously haven't been privy to those conversations, but if it were me on the bench, I would absolutely be questioning the need for that type of behavior, and really just trying to understand why they think that that is appropriate for the courthouse. I would also, from the bench, in open court, try to move the hearing along. Perhaps we don't need all the vitriol. Perhaps what we need are, can you explain the facts so I can help you, so I can give feedback, and so maybe there can be some settlement. There's also always the option of sending the case to dispute intervention at the courthouse, which I think can be a calming thing, or referring the case to conciliation, where a neutral third-party attorney can help. And I have seen that be very helpful when there are two contentious attorneys.
Appreciate that.
Thank you, Counselor. Thank you.
Thank you.
Counselor Siddle.
Thank you. Congratulations on your
Thank you,
Zoom.
Counselor.
And it was a pleasure meeting with you via Zoom.
You as well.
Yeah. So what I want to say is that thank you for putting yourself out there and sharing your personal experience in life and with your health. It's not easy to share that kind of information with anyone, but I would say that you beat the odds in many ways, starting from a child where your parents were separated and you were living with one parent and the other, being able to cope with that, and being a stepmother as far as trying to be the best person that you can be, and beating your cancer. Not everyone would have that opportunity, I would say, given my own personal experience with a family member having that disease. Most people would say life is not fair, but I thank you for your persistence and getting back and fighting as much as you can to be where you are now, because not everyone can do that. And you're not a statistics, as America would try to make it seem for some people who come from two-parent household or overcoming trials and tribulations within your life. And although that you are a practicing attorney, I think the best experience you could possibly have to be a judge is through those personal experience. And I just want to say thank you because, again, it's not easy. And my question for you is, given the fact that you've been through all these trials and tribulations in your life, what truly inspired you and what experience that you can take to the bench when you become a judge, so that when people from different walks of life come to you and they're looking for help and they don't know where to go, as a judge, what would you do differently than someone who didn't go through all these experiences that you have gone through?
Thank you for that question, and thank you for the kind words. I think far and above anything else, my experience with cancer has shaped everything in my life. I look at people differently. I look at how to treat people differently. I think that above all, people deserve respect and dignity, especially from the court. I think the court is, for litigants, a scary place to be, on top of them dealing with scary situations. And I would endeavor to make, as much as possible, the courtroom a more inviting place. I would always want litigants to think that judge is listening to me. Even if I disagree with a position of a party, I want to make sure that they understand that I have heard them and I'm really considering their side. And I want to do that with an empathetic eye, an eye on inclusion and kindness. And that all for me, I mean, not all of it. I was raised well by my parents, but that a lot of that came from how I was treated during my cancer experience.
Thank you. And I know divorce can be very nasty, and I'm glad that you can, through your experience, show that co-parenting can exist and that working together, putting differences aside for the benefit of the children, that they can come out successful. And my other question for you is, how would you ensure fair treatment for all community members involved in probate proceedings?
Thank you for that question. I think that it's important for the court to be consistent across the board. Anyone who walks into the court, regardless of their gender or their ethnicity, or their age, whatever it may be, should be treated the same and be treated well. I can't speak for the court as a whole, but again, that's what I would be trying to make my courtroom look like. If somebody comes into my courtroom, regardless of where they came from, they're going to be treated with the same level of dignity and respect.
Thank you. No other questions.
Thank you very much, Counselor Dolan.
Thank you so much. Really good to see you, Laurel. I
You as well.
appreciated your coming out to meet with me, and I appreciated the conversation, things we talked about. And I am glad that you shared today your cancer story, because I do think that overcoming a significant health crisis and issue changes your perspective.
Yes.
It makes you profoundly grateful for what you are able to do, because you have a time in your life when you can't do those things. And I appreciate what that must have been like for you to not be able to do all the things that you wanted to do and to use your abilities, and what it must mean to you now to be in a position to really be able to do what you're capable of. And I appreciate your being willing to do that.
Thank you.
I only have a couple of questions for you. I went over your resume. We had a good discussion. I'm impressed with your experience and your qualifications, your judicial temperament, and what I call judicial likability, which I think is really important. We had talked about two scenarios where cases get dragged out unnecessarily. Sometimes because there's an attorney who is frankly just racking up the billable hours, and sometimes because one of the parties is using the proceedings to harass or coercively control the other party. And you had talked about how you would address both those scenarios. So can you share that with folks, starting with what you would do when an attorney is dragging out the proceedings?
Absolutely. Thank you for that.
And what are the indicators of that? How do you spot it? How do you know when it's happening?
From the bench, I think that the telltale signs are, I mean, a lot of motions being filed. When the court provides generous feedback and it's not adhered to.
Can you give us examples?
So for an example, at any stage in a hearing, many judges will provide helpful feedback about the case. You know, they haven't heard the evidence yet, but a judge may say, listen, I think it might be a creative solution to do X, Y, and Z, and maybe you can talk about that, and maybe there's a solution that can come from that, and then you can settle the case. Sometimes an attorney will completely ignore that, and it's evident in what their filings continue to be. I think in cases like that, if the case proceeds to a trial stage and there's evidence to show that an attorney has really impeded the settlement process, there could certainly be fees or sanctions that are levied against that attorney if it's found that that attorney has done that purposefully.
We have a problem, is it?
I don't see it often. I don't see it in Worcester County often, and that's where I primarily practice. But from time to time, it certainly does come. To your point about litigants using the court to control, I do see that more often.
What are the indicators?
The indicators are somewhat the same. Multiple motions, frivolous motions that have to do with not the big picture issues in the case. There are several ways that I've seen successful judges deal with that. If there are 8 motions filed, those motions can be consolidated into one hearing so that the other side is not coming to the court 8 times. And if they have an attorney spending money to come to the court all of those times, a time limit could be put on that hearing. If there is evidence that these issues are being brought in a way that is not appropriate. And one of the most valuable tools that I've seen used is a gatekeeper motion, where before filing any motions, the court staff will review them to ensure that they're appropriate before going before the judge. And then, as always, if there is evidence that there are frivolous filings, there are fees and sanctions that can be levied.
And just one more question. I had asked you when we met what you wanted people to know about probate and family courts. Can you just tell folks this is an opportunity?
I don't remember the exact answer I said.
You said the misperception that they are one-sided from others.
That is, yes, absolutely true. I think any family law practitioner that you ask will say that they have had clients who worry about going to court because they think that the court is going to be so pro-mother. And I have not found that to be the case with the court. I think by and large, the court is looking to start at a place of, you know, if all things being equal, a 50-50 type of parenting schedule. If it is found that the father, in fact, would be better for the child to live with, I do think that the court gives custody to the father. But every case is so fact specific. And I do want people to know that if that's their fear, that's not something that they should worry about.
So they're not one-sided.
I don't-
One-sided for fathers. They're not.
I don't believe that. Maybe it was that way at one time, but in the time that I've been practicing, I have not seen that. I've really seen judges do what's in the best interest of the children.
Excellent. Thank you so much. I don't have any further questions.
Thank you, Counselor. We now move remotely to Counselor Ziegler.
Hello, good morning, everyone. Thank you so much for putting yourself forward, Laurel, and for taking the time to meet with me and just discuss your candidacy. We had a lovely conversation, just kind of going through some of the questions that some of my other colleagues asked you. So you had to answer several times, I'm sure, as to why this role, why now, what best prepares you. Um, I enjoyed reading through your questionnaire and your packet of application materials and learning about, numerous accolades that you've received, including the Super Lawyers Rising Stars for many years in a row consecutively, as well as your detailed explanation of your service um, in the law profession since 2012, and the fact that you've been in the courts for 3 to 4 times a week consistently, pretty much throughout your career in law. So to me, that I weigh that very heavily in my decision and in our conversation as we're exploring your candidacy. One of the things that we talked about is we talked about the role of the court, and we talked about litigants appearing before the court and the trauma that they may be bringing forward with them as they're entering the court system. And you discussed some, creative solutions to assist families, ways to reduce harm and trauma. Could you talk a little bit more about that? I really enjoyed your perspective on that.
Absolutely. Thank you so much for that question. I think trauma is something that we see, it's really prevalent in the family court, and it can stem from the case itself. It can stem from a situation where somebody is being abused, whether that be physically or emotionally, mentally, financially controlled, or it can stem from something completely different. There's childhood trauma. I think that it's important for the judges to be well versed as much as possible in recognizing trauma responses, someone dealing with trauma. And I know that that's difficult, and I'm not an expert right now, but I think that if judges are able to assess the litigants that come before them, keep an eye out, before the hearing starts, look for signs. There's body language, lack of eye contact, somebody who is afraid because their alleged abuser may be in the room. And I think that the ways that the court can get creative and deal with those situations depend on what the issue is, but certainly you could consider moving a hearing from in-person to Zoom to make a litigant more comfortable if it's not an evidentiary type of hearing. You could move a hearing to later in the day when the court is less crowded and there can be more attention put on a specific case without the litigants worrying that there's this packed courtroom of people hearing them. If it's a situation with an alleged abuser or somebody who doesn't want to face their alleged abuser, obviously, I think Zoom hearings could be even more helpful, and I would opt not to send a case like that to dispute intervention at the courthouse, so they would not have to be in the same room together.
Thank you. And as we continued our conversation, one of the things that you said, and I took note and paraphrased, and you can elaborate a little bit more. We dug deeper into your vision of the role of the court. You expressed that the role of the court is to be a pillar of the community and protect the family. With regard to probate, the role of the court is to assist, to provide justice and empathy, especially in cases when you're assisting families who are experiencing loss. And I found that to be very profound because I feel there are a lot of people who don't quite understand the impact that the court can have, and all the intricacies of both sides of family and the probate side that can impact family life. And so I wanted to kind of preface that and talk a little bit more about with regard to your vision of the role of the court, your priorities, should you serve on the bench?
You for that question. For me, one of the issues that I would want to become involved with and help with is providing, we already sort of talked about this, but providing more robust access to justice. In my work as a lawyer of the day, I have seen people be so afraid of the process and so just intimidated. Many don't speak English. Many need so much support and it's so intimidating. In a perfect world, I would love to see the resources be made available for low-income litigants or litigants who have other barriers to be provided with some level of access to an attorney, whether that be for a hearing or whether that be to be able to make a phone call and ask some, questions for legal advice. But my vision of the court would be to make it so everyone has a fair shake, not just litigants that can afford an attorney.
Definitely, I know there's some strides that have been made in that area
Absolutely.
that you had discussed, but it's good to know that's something that is, on your radar and something that is a priority to you as well. Can you talk a little bit about what you feel is the greatest strength that you would bring to the bench?
I think that my demeanor is a strength for the bench. I am consistently calm. It's hard to ruffle my feathers. I've seen much worse. I've dealt with worse. And so I really tend to focus on big picture things. I'm not going to get in the weeds over very minute details. I want to know, how are the children going to be safe? What is in their best interest? What is fair and equitable? I think that my ability to see through and focus on what's truly important would be my biggest strength.
Thank you. I appreciate that. And I appreciate you also, as my colleagues have said earlier, being so open and forthcoming about your experiences and how those would inform the way that you would adjudicate from the bench, and your passion for empathy and a holistic approach towards reducing harm within the courtroom and ensuring that folks have access to resources. So thank you so much for that. Thank you for putting your candidacy forward. And with that, I have no further questions.
Thank you, Counselor. Counselor Kennedy, any questions for the nominee?
Well, after today, you'll probably never see me again unless my wife smartens up and brings me before. Because I don't practice there. But we get complaints about judges. You'll be shocked to hear that. There are some judges that some lawyers and litigants don't like for some reason. And the vast majority, we were actually talking about it earlier today in our office, the vast majority of the complaints we get are about probate judges. I suspect that that's the nature of the beast is the reason it happens, because people are very obviously very emotional going into probate court. One of the things that I find happens with judges, and I'm sure you've seen it, when we're on the bench for a very long time, they kind of burn out. Get burnt out, right? Get frustrated with the whole thing. And they're working in a court, especially in a probate court, that lacks a lot of resources and is overwhelmed with work. You mentioned when you were in your opening statement, I was paying attention, that you're young and energetic, ready to take on the job. You're going to be on the court for a very long time. What are you going to do to keep from getting burned out?
Use all that vacation time.
We don't, in private practice, we don't get all that.
We do not.
Yeah, I know that.
Um,
That helps, but what else? I mean, you're gonna be sitting there for a long time and, you know, in the course of the next almost 30 years, you're gonna be handling thousands and thousands of cases, some of them really tragic.
absolutely.
I mean, and they can get to you.
Absolutely. I do think it's an issue. I have absolutely seen judicial burnout. I think that there have been a lot of steps taken in the past, even decade, to address the wellness within the court, and the mental health of the judges, which has been great. I think that moving forward, anybody but myself, I would need to keep a tab on myself and where I am mentally, and have a support system that I can speak to when I need to, whether that be my family or coworkers or, you know, what have you. I also think that I'm lucky that I have a young family. I have a big role to play in my son's life, and when I'm home, that's going to be my focus. Not to say that work won't be a big focus too, but when you're mom and at home, I think I'm going to have to delve into that more so. And so going along with vacations, I was just kidding before, but you know, when I don't want to miss out on my son's life and my stepkid's life, and I want to take the time to be there with them and watch them grow and help them grow. And so I think that will take some of the pressure off of constantly thinking about the very difficult role of a judge.
I talked to you about the chief complaint I get about the probate
Yes.
court,
You did.
which is trials getting broken up.
Yes.
And I get it all the time. If somebody goes in front of a probate judge for a divorce or whatever, and you know, a custody issue, and it's September, and the judge allotted 3 hours for the trial. They finished the 3 hours and only flew the first of 4 witnesses, 5 witnesses, and they go, okay, we'll see you December 5th. And by the time December 5th is around, you know, the litigant that says, well, she's really listening. She's really listening. All of a sudden they get there, the judge doesn't remember what happened, and you couldn't, maybe a little bit. You're looking at notes. You can't address credibility from a note. You know, you can't get demeanor from a note. And those are the things that you have to assess sitting on the bench. And that's the complaint I get. And to this day, I bang my head up against there and I say, why do they do that? It makes no sense to me. I'm in court every day. I try cases all the time. We start a case, we finish it, and everything else gets bumped. Why isn't it like that in the probate court? And what are you gonna do about that?
That is a great question.
It's a mediocre question, but that's okay. We should.
Question. I do not pretend to know why. But I do know that it is being actively addressed. Do you know that there is a program where judges will have a weeks-long schedule where they will be having trials? And I hope that that really, really eases the problem. I agree with you that it's a problem. There's nothing more frustrating than having a multi-day trial spread
I'm
out.
sure it affected you on a lot of cases.
Absolutely. It happens, and it's unfortunate, and it's frustrating for the clients because a attorney is preparing for a trial more than once. That's a lot of money.
I have no problem with lawyers charging money.
Well,
Not an issue for me.
it certainly can be consolidated and litigants can spend less money. But I think that some of the tools that can be used to try to mitigate is to really make sure the court or the judge is asking the right questions at the pretrial stages, limiting the issues that are going to be before the court at the time of trial, making sure that everybody understands that there are time limits. You know, for example, you have 3 hours to put on your case, you have 3 hours to put on your case unless there are extenuating circumstances.
But if that's not happening, I blame the judge for that.
I have seen it happen very successfully.
If you give a lawyer 3 hours and he's going 4 or 5 hours, that's the judge's fault.
I agree with you. I agree. I think reading the materials ahead of time so you have an understanding, and I think using your discretion from the bench to ask questions to witnesses that you need the answers to can make things certainly go more quickly.
All right. I know that Judge Casey has about 7,000 committees that look at all kinds of things in probate court. And I hope you get active on some of those, that maybe you can address some of those issues, given that you've had some experience.
Absolutely.
And I'm sure he'll be happy to have you volunteer once you get your feet wet on the bench. Probate. What do you know?
Well,
Easy question, what do you know?
I don't pretend to know a ton. I know the basics. But it's certainly something I would need to become more familiar with and
You're
take.
far from an expert in the probate area of the law, fair to say?
I'm sorry, say that again.
You're far from an expert in that area.
Far from an expert, but
So I shouldn't die if you're on the bench in Worcester County?
you know what I would do? I would, my first phone call would be to Judge Patsos, because I think she knows more than I will ever hope to know it in that area.
We vote on her, yes, is that today?
Yeah. Future Judge Pat.
Judge, so that's pretty,
I think she would be a big boon to the probate and family court.
you have a lot to learn, and I hope you get.
I do.
up to speed, because that's a problem in the probate court, is the judges that get on mostly. Very few probate practice. All right, I think you're terrific. We had a long conversation on the earlier, and you definitely have a calm demeanor, which I think is great. And it's gonna be a great addition to the probate court.
Thank you.
Oh, by the way, big fan. Your chairman. Big supporter.
It's pointed at me.
I know.
Thank you very much, Counselor Kennedy. We have had several good conversations. What, could you very briefly talk about your process? I mean, how long ago did you think about applying? What was your networking like?
Yeah.
I like Worcester County people.
I thought about applying around December of 2023. And there were open applications that were due in March, mid-March of 2024. So the process took, I think I spent about 40 hours on the actual application, which is long. And after applying, I applied in March, and I received a phone call that the JNC wanted to have a meeting in May. I spoke to several judges sitting in Worcester County and in Barnstable County. I do practice there as well. And I got their feedback and, found out what they thought of the process and how the process went for them. I spoke to you and found out how you think the process would go. And after the JNC interview, I didn't hear anything until I think it was October. So from May to October, that I would be meeting with Derek Hesselheim and Paige. And after that was October. I think then it was just a few months ago or last month that I heard I would be meeting with the governor. So the whole process took a little over a year. And I thought that I was vetted incredibly thoroughly. And I think that the hardest part was just the lack of knowing anything in between the meetings. I had no idea whether or not I was making it to the next stage. And that was the hardest part for me.
A big takeaway is to be patient,
Oh, for sure.
and that being in the pipeline can take forever.
Yes.
Reaching out to the folks in the community and in your area is very important.
Yes, I reached out to a lot of members of my community for support, for letters, just to kind of also get the temperature on things. I certainly wouldn't have wanted to go through this process if I didn't have the support of the community.
We have our most recent conversation, we touched on things that were already talked about today. Fee shifting. Earlier today, I asked about courtroom 9. And just, I paused to editorialize on that because in my role, yes, I come from the second largest city in the Commonwealth. However, it's not, no voter knows whether I'm advocating for local attorneys to be judges. No voter knows. But in the interest of justice and access to justice for people who live in Worcester County and other counties, we need judges who come from the area. I would imagine that would make it easier, not just in probate court, but everywhere, for judges to be allocated in a way that would reduce having multiple judges on a single case. For example, that's just speculation. You don't need to respond to that. But I feel like it's an access to justice issue. It's not really a Counselor DiPaolo loves Worcester issue. That's just my take. I don't, well, you can respond if you like, at least.
I tend to agree that it is an access to justice issue when you have so many different judges filtering through one caseload.
And we have that happen in other courts
Yeah.
as well. And the folks making the decisions, I mean, what are they supposed to do? Because we only have so many judges, they only live in so many areas, right?
Right.
Just an editorial comment. Lawyer of the day, you talked a lot about that. And my understanding is that Lawyer of the Day is kind of a program that differs from county to county.
That is my understanding.
And I think I heard somewhere in this hearing that it's often a partnership or initiative that's kind of the Register of Probate, the courts, maybe outside organizations like Community Legal Aid, something like that. So I know in Worcester, we have Community Legal Aid. Jonathan Menina does a great job there, and Counselor Kennedy's daughter actually works there now, which is great.
The legal counsel.
And they conduct, or they kind of Lawyer of the Day, they organize it, is that fair to
We
say?
facilitate it.
And so what happens, so they're in the courthouse and I take it there's a day, is it per week, per month?
They're no longer in the courthouse. I would say about a month ago, the Lawyer of the Day program moved from the service center at the Worcester Courthouse to the Community Legal Aid's office.
Which is
Which is down,
other end of downtown. I mean,
it's down the street.
it's
And
cold.
so- It is cold.
Why'd they do that?
I don't know. I did, in speaking with legal aid, I do think it has something to do with, like the availability of space at the courthouse. But don't quote me on that. I don't know if.
We have a nice courthouse, right?
It's a lovely courthouse.
Space.
I hope that it's something interesting that maybe all of us should look into. Why would that happen? It seems another access to justice. By virtue of the zip code I live in, I'm not going to get a stable judge in my courtroom, and I'm not going to get access to Lawyer of the Day. That sounds not like an outcome I want from
I
the
think-
constituents.
I
I want
think
the answer to that by the next hearing.
When I get Counselor Kennedy's here. Accomplished. I'm not going to belabor things. You're highly respected. Your hearing was excellent. I think you've answered a lot of concerns to the extent they even existed. I look forward to supporting you and putting your name forward next week when the council holds its assembly.
Thank you,
And with that, close this hearing.
everyone.
All right, hey Eunice. Why don't I go ahead and call our meeting to order on Wednesday, February 26th. I'd like to recognize Counselor Ferreira for offering some words of wisdom and leading us in the Pledge of Allegiance.
Thank you, Governor. Let's just pray for peace throughout all things in life. I pledge allegiance to the flag of the United States of America
And to the republic,
which stands one nation
under God, indivisible, with liberty and justice for all.
Right, good afternoon, everyone. I'd like to recognize Counselor Kennedy for a motion to record advice and consent for the financial warrant.
So move, Governor.
Motion made by Counselor Kennedy, seconded by Counselor Ianella. All those in favor? Any opposed? The ayes have it. I'd like to recognize Counselor Dolan for a motion to record advice and consent for the pending list of notaries public.
So moved.
Is there a second? Seconded by Counselor Kennedy. All those in favor? Any opposed? The ayes have it. I'd like to recognize Counselor Kennedy for a motion to record advice and consent for the appointment of Evelyn J. Patsos to the position of Associate Justice of the Probate and Family Court.
I make that motion and would just like to say it's an outstanding candidate.
Fantastic. Is there a second? Seconded by Counselor Ianella. Any further comments or questions regarding the appointment of Evelyn Patsos? Seeing none, I would ask Sonia if you could please help us by calling the roll.
Yes.
Counselor DePaul,
Yes.
Counselor Jacobs. Yes. Counselor Ferrera,
Yes.
Counselor Sill,
Yes.
Counselor Dolan,
Yes.
Counselor Ianella.
Yes.
We're not gonna offer an opportunity for Counselor Ziegler because you can't vote remotely. Okay, got it. We've got 7 members voting, 7 in the affirmative. The matter carries. I'd also like to recognize Counselor Kennedy for a motion to record advice and consent for the appointment of Sarah Toronto Flores to the position of Associate Justice of the Land Court.
Make that motion, Governor.
Thank you. Is there a second? Seconded by Counselor DePaulo. Any further comments or questions? Seeing none, I would ask our secretary to please call the roll.
Counselor DePaul,
Yes.
Counselor Jacobs. Yes. Counselor Ferrera,
Yes.
Counselor Sill,
Yes.
Counselor Dolan,
Yes.
Counselor Ianella.
Yes.
Counselor Kennedy,
Yes.
7 members voting, 7 in the affirmative. The matter carries. I'd like to recognize Counselor Ferreira for a motion to record advice and consent for the reappointment of Nicholas Bernier to the Appellate Tax Board.
With pleasure, I make that motion.
Okay, is there a second? Seconded by Counselor DePaulo. Any questions or comments regarding this reappointment? Seeing none, I would ask the secretary to please call a roll. Sorry.
Counselor Jacobs. Yes. Counselor Ferrera,
Yes.
Counselor Sill,
Yes.
Counselor Dolan,
Yes.
Counselor Ianella,
Yes.
Counselor Kennedy,
Yes.
Counselor DePaul,
Yes.
7 members voting, 7 in the affirmative. The matter carries. I think we do have a couple of new nominations. Andrew Hoffman to the position of Associate Justice of the Juvenile Court. I think Counselor Civil, that is your date and time assembly hearing to schedule. Do you have that scheduled yet?
I will have one by Friday.
Okay, so we're still working on that one. And then we also have Jeannie Reinhardt to the position of Associate Justice of the Juvenile Court, also in your district.
Yes.
Same thing. So by Friday, we'll circulate something to other counselors. I think that's everything. I'd entertain a motion to adjourn.
So moved.
Motion made by Counselor Jacobs. Seconded by Counselor DePaulo. All those in favor? Any opposed? The ayes have it. We stand opposed.
advice and consent of the council, Cecilia Moretti Haley, dated January 29, 2025. So we usually start off, if you'd like, Ms. Nominee, if you'd like to introduce your family and friends that came here today, feel free to do so.
Thank you very much, Counselor. Beginning at that side of the room, that's my husband, Bruce Hamlet. Next is my son, he's 13, Hunter Hamlet. My mother, Cheryl Brown. My sister, Angela Brown. My sister, Andrea Brown. My beloved friend, Claudia Magnus, she works for the probate court. Another beloved friend, David Nolan, he also works, retired from the probate court at this point. Longtime colleague and office mate, Janet Wallace. And Georgia Petropoulos will be speaking for me today, as well as speaking for me today.
Thank you very much. And I'm going to mention the Honorable Chief of the Court, Judge Casey. Thank you for coming, as you always do.
I didn't know that was part of
You
my.
need to sign the Pittsfield.
So we have here Council Iannella, Council Ziegler is by Zoom, Councilor Kennedy, Councilor DiPaolo, Councilor Jacobs, Councilor Civil, and Councilor Dolan here today. So we have a full force here today. We're going to start with calling your witnesses first, and then we'll hear from you, and then the council will be able to ask you questions.
Thank you.
So the Honorable Kevin R. Connolly, thank you for coming, sir. You can either sit, stand, or do whatever you want to do, and give us your thoughts.
Thank you, Councilor and council members. Thank you. It's a pleasure to offer some remarks in support of Governor Healy's nomination of Beth Brown. I know Beth in two capacities. She and I had a few cases together while I was still practicing. And I did note at that time, she's considerably younger than I am, and she remains so today. But at that time, I was extremely impressed with Beth's command of the law, absolute command of the facts of the case. We had a couple of nuanced financial issues, which she was very deftly able to negotiate. We settled the case, but I was really impressed, and my takeaway from that was we have a real star in the Plymouth County Bar. And since I arrived at Plymouth County on the probate and family court bench, Beth has been in front of me on countless occasions. And I did have an opportunity to submit a letter to the JNC, which really emphasizes the points that I think are so crucial to Beth's nomination. She is not only just an excellent lawyer, I thought she was a terrific advocate for her clients, but she also had a great measured approach to settling cases with underrepresented litigants who are on the other side of her case. And that showed me that she was not only an advocate for her clients, but she was also very respectful of the difficult position that other litigants can find themselves in when they are not represented. So with that, I will yield my time to the next speaker, but I did want to thank you all for considering my remarks.
Thank you, Your Honor. Does anyone have any questions for the judge? Kennedy, do you have a question?
No, it's just good to see you, Judge. We've known each other for a while. We're
Yes, Council.
friends. I don't go to the probate court, you know, I have a lot of respect.
Come on down to Brockton. Come on down to Brockton.
Yeah.
One time.
Thank you, Ron. I appreciate you taking the time to be here this afternoon very much. Thank you. Next, we're going to hear from our friend Georgia Petropoulos. Block is on.
Good afternoon, counselors. Thank you. I am honored to be here on behalf of Bethany today. I first met Bethany in, I believe, 2000 and then again in 2001 when she interned in the Plymouth County District Attorney's Office. I was immediately impressed with the way she would not only be a team player, but how she would kind of point things out to the DAs and police reports. She was always what was correct, not so much pro-pros or pro-defense, but hey, look at this doesn't look right. Why don't we talk to, the victim or find out what's going on with that? Later on, we had cases that kind of intersected. She kind of went on to do probate work as I continued on with criminal defense. And a lot of her cases would come about with restraining orders or criminal matters that would come about, and we'd work side by side on all of those cases. I have seen her several times and I've had the opportunity to witness how she handles herself in a courtroom. Her temperament, her humility for things that she doesn't know, and her willingness to want to learn more has always been amazing. In addition to that, it's the way she, as Judge stated, treats not only other counselors or opposing counsel, but specifically pro se litigants. She has empathy and her knowledge on the law is surpassed by none. And I think she would be a tremendous asset to the bench. Thank you all for your.
Thank you very much. Oh, don't go anywhere. We might have questions.
I've got like a.
Counselor Kennedy?
At least.
Please, I'd be happy to answer any questions relative to my friend.
Thank you.
Anyone else have questions for Attorney Petropoulos?
Thank you.
Well, thank you so much for coming up today. Appreciate that. Thank you. We'll hear from you, Attorney Brown, please.
Good afternoon, distinguished members of the Governor's Council. I want to begin this afternoon by expressing my deep appreciation to Governor Healy and Lieutenant Governor Driscoll for nominating me to the position of Associate Justice of the Probate and Family Court. I would also like to thank the members of the Governor's Council, Chairman Ferreira, Valerie McCarthy and her team, Chief Legal Counsel Paige Scott Reed, Deputy Legal Counsel Derek Hesselheim, and the Judicial Nominating Commission for their tireless efforts in seeing me through this process. Lastly, I would like to say a special thank you to Chief Casey and the many judges of the probate court, both sitting and retired, who have been steadfast in encouraging me to seek this position. I am honored to have had the opportunity to appear before you today. My story begins in Kingston, Massachusetts, where I grew up as the youngest of 3 girls. I was raised in a household where integrity, hard work, and service to others was a way of life. My father spent his career as a public servant, first working for the Kingston Fire Department and later the tax collector's office. My mother worked as a registered nurse and focused her career on the in-home care of elderly patients. My mother also wholly devoted herself to the care of sick relatives and neighbors, never accepting a penny for these special patients. My mother made it her life's mission to be a one-woman hospital, enabling those close to her to pass it home and surrounded by love. My parents demonstrated a work ethic, which included regularly working second jobs, volunteering for causes near to their hearts, and service to community. Back then, as it is now, childcare was hard to find and generally unaffordable. My parents endeavored to work opposite shifts so that they could share caring for us while sparing childcare costs. My model for parenting was one of true partnership, and my sisters and I were blessed to have been able to benefit from the best that each of our parents had to give. During these years, many of my days were also joyfully spent at my mother's side while she worked caring for patients. At my mother's side, I was marinated in her gentle kindness, unflappable patience, exceptional manners, and absolutely boundless empathy. I didn't know it then, but nothing could have better prepared me for a career in family law, and if I am fortunate enough to receive the support of this council, a position on the bench. For my sisters and I, it was inescapable that we would be college educated. When I graduated from high school, I knew that an expensive college experience was not in the budget. I applied and was accepted into the Archer Fellow program at Suffolk University. This program came with significant academic demands, but also offered a generous scholarship, which meant that my parents could afford to send me to school. For the next 7 years, I commuted from Kingston to Beacon Hill every day, first earning my bachelor's degree and then my law degree. I met my husband in 1995 as I was entering my freshman year at Suffolk. When we met, my husband already had a 4-year-old child named Alex. Despite my youth, I embraced the role of being a step-parent and know that I am a better person in so many ways as a result of that experience. Together, my husband and I have raised 2 extraordinary children. Currently, Alex is 33 and living on the West Coast. Our youngest son, Hunter, is 13 and attending the 7th grade. Hunter was born at 27 weeks gestation, weighing about 2 pounds. As a result of a birth injury, Hunter navigates the world with the challenges of cerebral palsy and chronic pain. When Hunter was born, I already had a busy law practice. For the first years of Hunter's life, I spent my days in the courtroom and my nights soothing a child that was often sleepless due to pain. As difficult as it was to see my child in pain, I know that we are fortunate in comparison to the challenges faced by so many others. My experience as a mother and step-parent have given me personal insight that I draw on often as a family law practitioner. Navigating a blended family was often challenging. In the early years, those challenges included the resolution of some issues by the court. Through that process, our family experienced the powerlessness of having our most important decisions made by a stranger. This experience ultimately propelled me into the practice of family law with a determination to support other parents and effectuate change. I got my first job when I was 14 years old, and I have been employed every day of my life since. I've held many positions, with each contributing to the person who I am today. I would like to highlight one such position this afternoon. While still in law school, I was employed by the Plymouth County District Attorney's Office. My first summer with the DA's office, I worked as a victim witness advocate. Through that role, I gained experience with the victims of domestic violence. I was so deeply impacted by my work with victims of abuse that for the past 20 years, I have operated a private pro bono program within my law practice devoted to assisting trauma-impacted litigants navigate the court system. As my practice grew, I expanded my pro bono work to include other clients whose circumstances limited their access to justice. For many years now, my practice has represented people impacted by language barriers, disabilities, mental health challenges, economic conditions, cultural barriers, and substance abuse, etc. I have found this work to be rewarding, and it has pushed the boundaries of my experience differently than my other client base. These meaningful experiences have shaped who I am as an attorney and a decision maker. I sit before this distinguished council asking that you confirm my nomination to Associate Justice of the Probate and Family Court. The 22 years that I have spent devoted to the practice of law in the probate court speaks to the depths of my knowledge. However, I hope that the details of my personal history, which I have shared today, will assist the council in evaluating those qualities which are so critical to the fair and compassionate judging, but can't be found in an application. If I am fortunate enough to be confirmed by this council, I will greet every day on the bench with the ethic of hard work modeled by my father, the boundless empathy modeled by my mother, and the relentless drive to effectuate fairness that makes me who I am. I look forward to answering any questions you may have regarding my nomination or my qualifications.
Well, thank you very much. That was a great introduction of yourself, and I appreciate it very much. Now we're gonna leave it up to the council to ask you questions. We're gonna start to my right with Councilor Civil.
If I may,
I'm sorry, I did forget.
Councilor Iannello.
Councilor Iannello, who made a miraculous recovery. I don't know if he wants it public, but he was hospitalized a few days ago and got out of the hospital hours ago and came because he's a great public servant. And I did say that I would call on you first, so thank you for reminding me. Councilor Iannello.
I don't have any questions, just a comment. You and I had a lengthy conversation over the telephone. In addition to that, we met in person. I met one of your witnesses in person, Attorney Petropoulos. All your witnesses, Judge Conley, did a great job. Again, it's always good to see the chief, big supporter, and your own counsel. As soon as your name was nominated, you were nominated, I should say, by the governor's office. He called me, so he's a strong supporter. I don't have any questions. I think you're going to be a great addition to the probate court. When your name comes before the council, you can count on me.
Thank you.
Thank you, Councilor. Thank you for being here today. Rapid recovery.
Thank you.
Thank you. Councilor Civil.
Thank you. Congratulations on your nomination, Bethany. Thank you for meeting me. It was a pleasure to learn about you as well as your family experience and your experience professionally as an attorney. My question to you would be, given the opportunity to be a family probate judge, what roles can you play in helping parents battling with addiction?
So in the probate court, we have some ability to divert people to some programs that would be able to assist with issues of addiction. It's actually a very, very important issue in the probate court, and I'm happy that you raise it as something that we keep at front of mind. I think an unfortunate aspect in the probate court is that in some ways, our first job is to protect the child, the best interests of the child. So our first job would be to make sure that a child was safe in whatever way that they were able to be continuing to have a relationship with their parent. But I would say something that I've seen through my practice is that children love their parents, and they love their parents deeply, regardless of any hurdles that those people might be going through. So I think that one of the more important things that I can do as a family law practitioner is to make sure that those bonds stay in place as best as they can safely while a parent is navigating their way through addiction or whatever other challenges they have. I think it's important not to be overly restrictive, so only to the point that the child is protected in the circumstance, because to reduce the relationship between a child and any parent more than that, I think does a disservice to the child.
Thank you. I know that we talked briefly about, my experience in probation and how, we have our probationers take drug testing, but you also have other experiences in how an individual can get more resources into getting treatment without just letting them be on their own. Can you talk a little bit about some of the other resources that you know that parents can get access to when it comes to addiction treatment?
Yeah, so something that comes to mind for me that we often use in the probate court is something called a sober link program. So a sober link program is, it can be ordered by the court, or it can be something that parties agree to voluntarily. And it's a program where through someone's iPhone, they can randomly or at certain intervals be required to alcohol test remotely. It's done through FaceTime. So that can be done to either chronically monitor someone to see if they are on the path to sobriety. And it's a very good program because it's randomized. So the person would not be able to plan the tempo of how those tests would take place. Another way that that program is used is perhaps to do testing before and immediately after parenting time. So that would be able to alert a co-parent if someone was under the influence of alcohol shortly before the visit, or at the end of the parenting time, or at the end of the parenting time as well.
Thank you. And my last question is, I know that we spoke with your parents and what they have gone through. I believe it was through an estate, and what you've experienced and how you want to make sure, given an opportunity to become a judge, that everyone that comes to you that goes through that same issue or process that your family was going through, you want to make sure that they have a good experience. Can you explain a little bit as to what you've learned throughout the experience of your parents?
Yes, and thank you for giving me the opportunity to talk about that. So my parents went through an estate litigation. They were, good members of the community, had never been involved with the court process prior to their experience in an estate litigation. And I saw the way that being involved with the court weighed on my parents as they aged. It involved a lot of discovery, many court appearances, some legal issues. And there was a period in time after it had sort of dragged on for a period of years where I saw that it was really weighing on my father. As an elderly man who was having trouble sleeping, he was thinking about it all the time. And there was an afternoon where I called one of the people here to support me today, Attorney Wallace. And I said, I don't care how you settle this, but you need to settle it immediately because my father can't handle it anymore. I can see that he's not sleeping. And the next morning he had a heart attack and passed away after we had that conversation. So for me, when I'm on the bench, I know that a date on my calendar that might be 6 months later, to me, that just might be scheduling, or to a judge, that might just be scheduling. But for me, as a person on the bench, I will know that to that litigant, that could mean life unlived. It could mean nights not slept. It could mean family events that they don't enjoy. So I know that one of the things that the court is doing to try to enable us to process cases faster is have people like me here with you today to add to the court staff. But it will truly be at the core of the things that I care about in making the process fair and so that everybody can participate in it, to also make it expedient.
Thank you for sharing that, because I think our constituents need to hear that, because not only that you went through that process and you lost a loved one through that process, we know how cases could drag on over and over. So given that experience, you'll know when you get a case to make sure that it moves along appropriately. So thank you.
Thank you for asking that.
Thank you, Counselor. Counselor Dolan.
Thank you so much. Congratulations, Attorney Brown. I know Counselor Ferrer is a big supporter of your nomination, and I'm to say I really appreciated your coming out to the Concord Free Public Library to meet with me. I was really impressed with your qualifications and your experience and your qualities. So thank you for all of that. And shout out to a liberal arts major. You major in philosophy and history. Liberal arts are very important, especially now. So I really appreciate the fact that we're looking at a judge who has that background. One of the things that I asked you about was my concerns about people, usually women, who are victims of domestic violence and victims of coercive control, and how difficult it can be for them to face their abuser in court. So I asked you what you would do to support those folks, and you gave me a number of points which I thought were excellent. Can you just share with us what you said?
So I really enjoyed talking with you about those issues, and thank you for bringing them up again today. Especially issues of coercive control, how our statute has changed recently. Those issues are layered and nuanced because they are combined with the concept that we need to protect a victim from what has become abuse, with the fact that people are entitled to utilize the litigation process and entitled to defend themselves. So my perspective on coercive control in the mode of bankrupting someone, if you will, or utilizing litigation as a mode of domestic violence is that the judge plays a large role in intersecting in that behavior and doing what you can to forestall it before it gets out of control. So in my experience, there are a large subset of people that they're before the court for the first time. They don't perhaps understand when they are filing motions over and over repetitively. And sometimes they do understand, and they're doing that for a very specific reason. So if I were on the bench, I would, when I saw that something was feeling to me like it was starting to become an issue of coercive control or abusive litigation, I would first start with a verbal warning to the participants that these are perhaps issues that we had dealt with on a prior date, that absent new evidence, there's not reasons to bring them before the court repetitively, if that was one of the issues. The next thing that I would probably do is warn people that if you require someone to come to court for a reason that's not valid, you could be subject to attorney's fees. And the last thing that I would mention to the court, and this is before you get into any kind of 2098-9A orders or restraining orders regarding this, would be that the court can implement gatekeeper orders. So a gatekeeper order is when a clerk or another person in the judicial system is assigned to review pleadings before those pleadings make it before the judge. And in my experience, when you find a case where that type of practice is happening, and I use the colloquial term bankrupting because I think it explains sort of what's going on. When you find that that is happening, those gatekeeper orders can really step in and really put a stop to that behavior and filter out what needs to be heard by the court and what doesn't need to be heard by the court, saving the person who's been subject to that a lot of money, both parties, you know, the angst of coming to court over and over. So I've found that those have been particularly helpful.
Thank you. And you also talked about some logistical things, which I think would be really good for folks to know are options. You talked about scheduling hearings for later in the day so that there aren't as many people in court. You talked about having court officers walk folks back to their car. Or keep, that's not what you said. You said keep the parties away from each other, offering a Zoom hearing so people don't actually have to be physically in the presence of their abuser. I really appreciate all those things.
Thank you.
And I just want to talk about one other thing, which is that you very kindly introduced me to some case law. I don't practice in probate and family court. You brought up a case called Kavanaugh. And you said this had been a big change and had caused some controversy. So can you just explain to folks what Kavanaugh is, what, as you did beautifully for me, what the implications are and how you as a judge would apply Kavanaugh?
So Kavanaugh is a court decision that I believe that we got in September of 2022. I believe it was 22, not 23. And in the Kavanaugh decision, Kavanaugh essentially upended the way that a lot of judges were looking at the issues of support. Prior to the Kavanaugh decision, most judges were taking the child support guidelines, and our child support guidelines have a cap. If you earn, or you as a family earn less than the cap on the child support guidelines, then your money would be put into the calculator and that would generate an assumed or presumed amount of child support that would be paid. Some judges were being creative and doing some other things with combining alimony and child support. But generally speaking, I would say that was how the majority of judges were handling it. When after Kavanaugh, the Kavanaugh decision essentially said that child support is reserved for children, but that if there's a circumstance where a spouse would be entitled to alimony as well, that the court should do a three-pronged analysis. The first analysis would be where you would run some alimony guidelines, which gets a little bit more complicated because our statute says 30 to 35% of the difference between the parties' incomes. But after the Tax Cut and Jobs Act was passed, we know that that's no longer deductible. So there's some, there's been some accounting done to bring those numbers down to essentially equalize what they would have been before. So essentially, we would figure out what alimony is, take the alimony from the side of the payor, add that to the side of the payee, and then run the child support guidelines, which would affect the person paying two numbers, a core number as alimony, and then a second lower number as child support. The other number that we would give is what would be the child support number if we just ran it organically. The idea being it should never be less than that. The third calculation that needs to be done is a calculation that shows the tax effect for the two parties once you do this double calculation. I think the piece of that law that stands out that's not been fully determined at this point is Kavanaugh considers that a judge will have had the opportunity to determine a series of factors that would not generally have been determined at a temporary order. So there is some disagreement, some conversation maybe is a better word, among judges as to whether Kavanaugh should really be something that we would be doing at a trial stage where we have all those factors to be able to put in place, or if Kavanaugh is something that we would do preliminarily as a temporary order before the rest of those factors are in place. Hopefully that wasn't more than what you needed.
It was fantastic. I really appreciated it, and I appreciate your being here today. Thank you so much. No further questions.
Thank you, Counselor. Counselor Kennedy.
I don't have any questions for you. I do have a couple of comments. I spent a lot of time beating up the probate court because of issues that I hear about. But I do have to say that they made some vast improvements under Judge Casey's reign as Chief Justice. Councilor Ferrara obviously is a huge fan of yours, and I'd vote against you, but I'm afraid of Georgia. Like any good lawyer is in the courtroom, we're all afraid of him. So I'm going to vote for you next week and the week after, depending on where things go. But we had a long talk. You answered all my questions, and I think you're an outstanding candidate.
Thank you, Counselor.
Thank you, Counselor Kennedy. Counselor DiPaolo.
Thank you, Counselor. Good afternoon. Congrats on your nomination. First, like myself, Counselor Ferreira lives outside of Boston, and he's a great advocate for his region and for his nominees, and that includes you. So I appreciate that as well, and I hope
Thank you.
I can learn from Counselor Ferreira and deliver for my region as well. A bunch of my questions have actually already been addressed. I listened intently in the discussion about that started with coercive control and led to abusive litigation and the fee shifting. And one thing that some of the folks who've had those kinds of experiences in the court as litigants come to me and tell me is that I've heard of experiences where in their view, and I'm only hearing the context of their side, it sounds like the judge could have been a little more proactive, maybe didn't have to wait so long to impose those fee shifting and to even inform that the fee shifting was a possibility. So I appreciated that. The other thing is our courts, I'm very glad to see our courts are moving to incorporate trauma-informed practice. And I heard good discussion there as well, because sometimes we hear that and people will say, well, I'm going to be kind in the courtroom, which is kind of baseline being a decent person. It's not trauma-informed necessarily. And you offered some specific examples, which I'm very glad to hear, and I don't always hear. So just a couple of questions. One is the Pathways program. Are you familiar with that?
Absolutely.
Could you tell us, really briefly, but could you tell us what that's about and how it's benefiting the courts?
Absolutely. In a nutshell, the Pathways program is something that's been instituted by the probate court. I think Chief Casey has been really a proponent of that. And it's where there's some court staff, the assistant judicial case managers, intervene in cases early, cases that seem like they might have a likelihood of settlement. And they meet with those parties via Zoom and their attorneys early on in the case. There's some paperwork, some documents are provided, some memorandums are provided, but it gives a really early time for the court to check in with parties and see if the cases can be settled. And I have to say, I think my resolution rate is over 80% at Pathways. So for me, that is excellent in two ways. It solves a lot of cases really early on. But when you think of it as an access to justice issue, I think it's very important, because if you have cases where people are pro se, it's an opportunity for them to hear from someone from the court without having a lot of legal paperwork that would be difficult for them to produce. And if you have a case where there might be a person who's unrepresented with litigating with somebody who's represented by a lawyer, it gives an opportunity to open up dialogue with a referee, if you will, or someone who can be unbiased. And I just think it has solved so many cases early on. I think that it has been wonderful for the court. I couldn't speak more highly of it.
And that's the court, that's not the individual register of probate, right? That's the court.
Right, as far as I know, it was originally a satellite program, but it is universal now.
It's one of the good things I hear about a lot,
Yes.
and Justice Casey deserves a lot of credit for that. Another thing I hear from practitioners, not from litigants, although I'm sure I would hear from litigants if I talked to more pro se ones, is that they tell me that there's different practices in different counties. And an example I was given, you tell me if this rings true or not, was that different counties might, for example, have different requirements regarding the order of paperwork when something's filed. And I've spoken to attorneys who've had filings rejected because the documents weren't in the they were all there, properly complete, but they were in the wrong order and they got kicked back. And so I would imagine that creates delays.
Absolutely.
I would imagine, right?
Absolutely.
And I would imagine it happens more frequently to pro se than to practitioners. That's just my speculation. Does that ring true to you, that there's kind of these picayune aspects of the administrative side of things in the registrar's office that, I don't know, that create barriers to access to justice?
That is a great question. And I think that it's probably something that is burdensome for practitioners more than litigants, because a litigant would probably only be in one court. So the practice that they had, once they learned it, they wouldn't be comparing it to other places. But especially a younger attorney.
Yeah.
If I can give you one example, I've been practicing law so long that when I first started practicing, Bristol County had its own Bristol County white paper that you could only buy from WB Mason in Bristol County. I still own some, should I ever need it.
Well,
But
for the WB Mason salesperson.
yes, yes.
Convincing salesperson.
So one of the rites of initiation there was that you had to know that you had to file on the Bristol County white paper. Now that went away some time ago, so that's probably extreme. But the way that that appears now is that different courts manage their lists very differently. So for example, in Plymouth County, we have an open list for motions. Anybody that wants to have a motion heard can file it on the judge's motion day. In some other counties, motion lists are closed, meaning you have to get permission well into the future as to when you would be able to hear a motion. And it can really change the strategy of how cases are done. And in my experience, when you have a closed motion list, what ends up happening as a practitioner is a lot more cases become an emergency. Because if I can put something on the list with 7 days notice, 99% of things aren't an emergency in 7 days. But if you tell me that I have to wait 90 days to be heard or 120 days to be heard, then so many things need to be presented double as an emergency and then the ultimate motion. So yes, there is still significant lack of uniformity between the counties.
And because the council has seen several probate nominees recently, I've been getting a lot of outreach and doing a lot of outreach with the probate bar. And I just keep hearing these things that seem troubling, like these aren't substantive, these are not substantive issues, but they're creating these barriers to justice. Seems like an area for improvement, and it's not anything the judiciary can do. Seems like
Well, maybe there might be.
Elsewhere, no?
I think you're right to some degree, but a lot of the positions that you're appointing at this point are circuit positions.
Yeah.
So that means that the same one judge would be going to more than one county at a time.
Right.
Perhaps one of the things that we could do is take a look at what's working well in each of the different counties and be able to have some progress.
Transfer those best practices.
Transfer the best practices, yes.
Yeah. Presuming all the stakeholders were on board, right?
Absolutely.
Just the judges, but.
Yes.
And then finally, I have a question of actually a point of ignorance that I forgot to ask someone last hearing. Is there ever occasion where children are removed by probate family court judge? Like, in other words, taken into state custody?
Yes, that is possible. When two parents appear before the court and the judge has a concern that neither one of the parents is fit to care for the children, the court can transfer custody during that hearing sua sponte to the Department of Children and Families. But I would say, in most circumstances, it's my understanding that after some supports are put in place, that the Department of Children and Families usually places the children back with one of the parents, if that's possible. They don't always go out of their home to a third party. That might be necessary if the circumstances demanded that, but they don't always.
Interesting corollary to my previous question, which is that DCF practices vary by region as well. Standard procedures for DCF vary quite a bit. If I properly understood your conversation before, you were kind of talking about the fact that sometimes when it's a gray area or when it's a borderline decision that, so correct me if I'm wrong in understanding this, that children sometimes in the gray area situations are better served being with the parents than removed. Did I understand that correctly?
When we were talking about the substance abuse issue or a number of other issues that might cause a judge to have pause to have a parent have, say, shared equal physical custody or even expanded parenting time. The point that I was trying to make is that even when children have parents who have challenges, those children still love those parents and desire to have time with them. So I think that it's important to put things in place that allow the parent to have as much access safely to children, even when you're trying to protect them.
I'm grateful for that perspective because I know it must be such a difficult decision. I'm glad I'm not ever going to be a probate judge. But I have like my dog-eared reports on research about like the consequences of separation when there was the possibility of more interaction are actually in many cases graver than keeping a child in a neglectful situation or something.
It's a very important issue to raise. It's something I have front of mind. Even in my personal experience, I've seen how children have been deeply impacted by being separated from a parent who undoubtedly the parent needed some supports in place.
Right. I probably used up all my time, but I appreciate your thoughtfulness. Thank you.
We're just gonna gavel you out.
I'm sure I've never been gavelled.
Never. Councilor Ziegler has joined us on Zoom, and she was earlier, so I apologize, I didn't see you raise your hand. So please feel free to speak now.
Thank you, Council Chair. Thank you, Ms. Brown, for putting your hat in the ring, and for also taking the opportunity to meet with me and have a conversation to allow me to ask questions of you and get a sense for you as a professional, you as a candidate for this role. We talked about several things. We talked about, why this role was something that you were drawn to, why now was a great time. And in our conversations, we centered a lot of our discussion around the role of the court and the challenges that you see the court may face or is currently facing, and what your role would be in order to support alleviating some of those challenges. Can you speak a little bit to that? I really enjoyed your response relative to that question.
So I don't know if I remember exactly what we were talking about at the moment.
Yeah, so when we were talking about challenges, you had brought up the length of litigation of cases, and creative ways of trying to expedite that, and looking at how to reduce harm and to support a efficient courtroom.
Yes, so yes, that's a great question, how we can reduce harm for litigants that come before the court, because one of the things that we need to be focused on is not re-traumatizing people who already have experienced trauma and they're coming to the court. I think that we talked about some of the same things that I had talked with Councilor Dolan, but maybe I could add some things that, I didn't she didn't mention or that come to me additionally. So I think it's important when you have people that are trauma affected before the court, it's important for a judge to be educated in the differences in the way that those people or that population presents. Sometimes they can minimize things that are really, really important, but they might put a lack of emphasis on it. They can be confused in their testimony sometimes, and some can, seem like they're moving a little too fast through the evidence or a little bit too slow. So I think that it's important for a judge to have top of mind that trauma impacted witnesses may testify differently. And some of the things that we can do to try to make a court hearing less traumatic is some of the things that we've mentioned in the past. So perhaps we would make sure that there was an advocate available for someone, perhaps if they were seeking an abuse prevention order. If we were concerned, we could make sure that there was a court officer in the room that was perhaps standing between the parties. We could make sure that the defendant was held back in the room so that the person seeking the order was able to get to their car safely. We can have Zoom hearings. If something was highly confidential, in some circumstances, we can't close a courtroom, but we can help the parties select times in the day when the courtroom is more likely to be empty to give them some space to be able to tell the court everything that we need to know to make the correct decisions. So did I answer your question entirely?
Yes, I just wanted to make sure we touched on it because you did mention quite a lot there that I think was helpful to put on the record. Can you speak to what your priorities would be on the bench should your appointment be confirmed?
So the first thing would be something that I already mentioned today, which would be the speed at which cases move through the system. I think that that's very important, and I'm really thrilled to see that some of the resources that need to be put in place to have that improve are being put in place, specifically these appointments. Another thing that would be really important to me as the judge would be to make sure that all litigants, but particularly pro se litigants, were fully heard by the court and felt fully heard by the court. And something that I know I will be committed to as a practice on my own is that when I issue temporary orders, I will be careful and conscientious to write in my temporary orders why some bit about why I'm making the decisions that I'm making, because I think that helps people that come before the court understand that they were heard and why the decisions that are being made, and what perhaps might also be a pathway if they're not liking the solution or they wish the solution were different, a pathway to a different point in their family that they might be seeking.
Thank you. Can you speak to the resources that the court currently has available, in terms of which resources you'd be looking to expand or you think are missing within the court at present?
I think probably closest to my heart would be to speak to something that I think is missing in the court. So we have a lot of great programs in our court as far as Lawyer of the Day programs, ARC programs. So an ARC would be an attorney representing a child, or a Lawyer of the Day program would be where someone could go and sit for 10 or 15 minutes and get some paperwork filled out to begin their case. Something that we also have some services where people who have been the subject of abuse, but also have some financial difficulties, can get representation on a little more long-term basis. I think that a concern that I have seen, and something that in my own practice I have tried to see if I can assist my community with, is there's a great difference between helping somebody get some paperwork started and seeing them through a case. Because many people don't know how to draft the paperwork, but then once they get to court, they don't know what to do with that paperwork. So that's why when I looked out at the many different programs that a lot of my colleagues participate in, I said, I think the real thing that's missing in my community is that there are vulnerable people that don't just need me to help them fill out a financial statement. They need a longer walk through that process. And what I know about my colleagues is when there's a program, lawyers flood to help. So I think that it could be, if the solution could be simply like when we started the ARC program, or when we started the Lawyer of the Day program, that if there was a program to help vulnerable people that have been designated by the court in some way, I really think that my colleagues would feel exactly how I felt and would be, you know, driven to try to see if they could help some of those people. But that's exactly why I did the program in my office the way that I did it, was because there were so many people that fell through the gaps for one reason or another, but so desperately needed help.
Thank you. I appreciate you taking the time to be intentional about answering my questions, and wanted to further congratulate you on just getting to this stage in the process. And with that, I have no further questions.
Thank you, Counselor. Next, we have Counselor Jacobs, who I have to warn you has multiple pages tabbed with different colors, so I'm not sure about these questions, but Counselor Jacobs.
She knows, right? Because I had the same tabs when we met. But we've actually discussed all the tabs already. So I wanted, actually, this is one of the things we did talk about, but I wanted to give you an opportunity to talk about it here, but also maybe think about how, and let me back up. The question is around the work you've been doing for the last 10 years on the pro bono side, that you've been kind of creatively culling together a network who knows to send you specific types of cases. And so I just wanted you to speak to that, what you're attempting to course correct in terms of justice with those choices, and if you see a route towards a more formalized approach, be it through the courts or be it through bar associations or other community organizations that provide legal services. If you see something that could be more institutionalized across the state, based on what you've been doing.
So the thing that drove me to establish a program like this was two things that happened close. I served as Lawyer of the Day. I showed up, I filled out a lot of guardianship paperwork and a lot of financial statements, and there was no, and it's a great program, but there was nobody determining whether there was a need-based or if it was just people that were looking for some extra help. And I recognized that I was only helping with this little piece, and I thought to myself, well, how do these people take this and turn it into what they need the judge to know? And at that same time, chronologically, I had a doctor reach out to me and say, I have a person that I don't know where to send her, but she absolutely needs help. She had been abused with, as the judge commented, the worst injuries that he had ever seen in his courtroom. I mean, her eyes were bloodied, the whites of her eyes, by the abuse that she had suffered. And that was a woman from a very wealthy town. She lived in a very wealthy household, but she had been completely cut off from any resources whatsoever. And she didn't need help after she applied for a program 6 months from now and went through an application process. She needed help right then, that day. And she was so scared and so broken that she needed somebody that would go to the courthouse with her, stand there with her, hold her hand, and promise to be there on the other side of that hearing when all the things that would go wrong, that she knew would go wrong, did. So that was where that program from my office was sort of born, was that person wouldn't have fit into any program that we have out there. And there's so many other people and other very different examples that I could give you as to how that program was used. There was another another case where there was a mother who was very vulnerable and had a husband that had significant mental health issues, and he had holed himself up in the house and wouldn't leave the house under any circumstances, so he couldn't be served. And so there was difficulty regarding getting jurisdiction over the marital home so that it could be transferred to the wife, because in Massachusetts, we require in-hand service. So that person had gotten to the point where she was in tears at the courthouse saying, give him everything, I just want my kids. She was homeless, and that she would stay that way because she didn't know how to make it any better. And I just happened to be in the right place at the right time in the right court person, you know, pointed out the problem. And as an attorney, I was able to navigate that and help her figure out jurisdiction. And that was a real life change for that family. Those children ended up, they sold that house, they sold it for a lot of money, and they were able to move into housing. So for her, it was a great change in her life. And to me, it was only a few hours of work. So I think I would reiterate again that my colleagues are so eager to help. They really are. When there's formalized programs, I don't think it would take much more than somebody finding a way to have these referrals made to lawyers that are willing to take them. And I think my colleagues are so generous with their time that they would be thrilled to do it.
I hope that does happen, because you definitely articulate a clear need that's outside the current criteria that I'm sure is across the state. There's people in similar circumstances who would benefit. I appreciate you proactively taking on these kinds of cases, and so I hope that will become more of a systemic thing. I wanted to ask you to articulate what you think are the pros and cons of judges in probate and family side, particularly having a case throughout its longevity from first introduction to potentially the aging out of children, which could be an 18-year-long experience possibly, or even longer if there's other, you know, guardianship type issues going on with adults in the family. Can you just articulate what you see as the benefits of that and possibly the challenges or drawbacks of that?
Maybe I'll start with the challenges because I think they're more defined. So one of the challenges would be if, for example, a judge had grown to have some type of a bias in the case, but the law does protect that, because if a judge feels like they're not able to you know, handle a case without having the correct distance, that they could recuse themselves. I
They
think
have the awareness and the accountability to do that.
do so as well. So that would be one downside. I think another downside is something that comes up in these hearings a lot, which is when we have a one judge system, it makes it very hard to have trial dates be consecutive. I think that's why sometimes people who practice in the district court will come to the probate court and be frustrated that they don't see contiguous practice days, but that's because if it's a one judge system, we have to do contempts and motions and pretrials, and then we have a couple days left in the week to do trials. And in the district court, there's one judge that's doing arraignments, one judge that's doing pretrials, and one judge that's doing trials. So it's not that the probate court judges don't see value in having a trial be contiguous. Wouldn't want that. Ideally, if they can do it, it's because the chosen good or the better good has been determined to be to have one judge handle a case from start to finish. So I can tell you, I'm somebody who practiced under both systems. I was an attorney when we could judge shop, if you will, and much longer been an attorney when judges have been assigned to the cases. And the benefit of having a judge assigned to the case is it's not uncommon when you walk into a courtroom to have a judge know the names of the children of the parties. They know how frequently they've seen the parties. They remember things that they've said in the past. And even if they don't remember, they remember body language and how they treat each other. And there's a lot of information that wouldn't be contained on a docket that you'd never see in an order that those judges have in their hearts and souls about cases that they have seen all the way through. So I think that if we were to go back to a system where judges just handled cases one at a time, as much as the trial might be easier, I think the forum shopping would become much more of a danger to our system. So I think the way we do it now, all told, is the correct way to do it.
I appreciate that. One thing you didn't speak to that I have questions about is the emotional impact on a judge from the, you know, shepherding a family's case, especially if it is highly volatile, if there are significant issues in the home that affect the children, that affect the parties, and being kind of invested in them for the long haul. My concerns more about like the judge wellness, right? Self-care, mental health, and the emotional labor of that. How do you think you would navigate that and do the work to preserve your own, you know, self-care and mental well-being?
So my first reaction to that would be, that if there's a case that's, has such difficult facts that it's weighing on a judge emotionally on a long-term basis, then my first thought is the family that's being impacted by that. That means that there are either children that are going through such a traumatic circumstance that the judge is becoming impacted by that, or just a couple or a family in an estate matter or something. And I feel that when you raise your hand to take this job, that one of the things that you commit to do is to see these families through these issues. So there might need to be resources in place, perhaps talk to colleagues. Maybe you need to take a walk, take a break, do other things. But I think when you agree to take on this job, you agree to see these families through these issues. I don't feel for myself that it would be fair to bow out, even if it got hard for me, because I would be leaving somebody in an even harder circumstance and they can't walk away.
What are your thoughts about specialty courts or specialty sessions for probate and family around things like families where mental health issues or substance misuse issues or the overlap of the two are present? Do you think that's something that A, does it exist, and B, should it exist?
It doesn't exist in the way that you just described. We do have something called the fiduciary litigation session. So that's taking the more complex cases on the probate side and saying, okay, we'll have some judges that are very experienced handling just those issues. I think that if we found certain areas that had great need, such as mental health or substance abuse, I think that it could be a really good idea to have one judge or a series of judges focused more on those issues, because as human beings, we don't show up to the court necessarily versed in everyone's culture or all the issues surround mental health issues or substance abuse. So the more a judge can understand those issues, the better they can make a decision. So if resources were available, I think I would support such a thing.
I don't have any further questions. It was really a pleasure getting to know you, and congratulations again for your nomination.
Thank you, Counselor. You and I spent significant time together. Appreciated getting to know you. When I first heard your name, I immediately texted Matt McDonough, the probate court in Plymouth, and I want to read verbatim what his response was. Started to do my due diligence. He said, she is the best. I've known her since grade school. We graduated high school together. She's a brilliant lawyer, compassionate, cares about the community, and is raising a family while managing her law practice. So that meant the world to me when Matt McDonough said that. And then going through your resume is just astounding. The cases that you have advocated for are extremely interesting. To say the least, we could go on all afternoon and probably a couple more weeks talking about them. From like mom abandoning her child and hitting the lottery and dad having to chase her down to other really nuances in the law that you've done. But most importantly is your compassion as a human being, your ability to manage your law office with a complex family dynamic, as you put it. Your extensive pro bono work has been astounding. Your expertise in complex and forensic cases is also amazing. And you're just a great human being. So I wouldn't be afraid to go before you as a litigant, not that I've do ever. But I think you give everybody a fair shake. And that's the bottom line. Somebody that went through the process a lot of years ago and didn't feel that at the time. I feel that people that will go before you will all get a fair shake. They're all gonna feel that they've been heard and you're gonna be a fair judge. And I think reading the room today, I think you're gonna do pretty well when we take the vote in the next week or two. So I want to thank you for all your service, all your pro bono work to all those people that needed it. And I want to thank you for applying. And I want to thank the governor's office and Dara and Paige for getting you to this process today. That concludes the hearing.
Thank you.
Starting the meeting. Here. My name is Tamisha Civil. I'll be chairing this hearing this afternoon. We will read a letter from the governor. Dear counselors, I am pleased to nominate Brian T. Salisbury to the position of Associate Justice of the Probate and Family Court. I submit this nomination for the advice and consent of the Executive Council pursuant Part 2, Chapter 2, the Constitution of the Commonwealth of the Massachusetts. Sincerely, Governor Healy. And Attorney Salisbury, would you like to introduce friends and family?
Sure, thank you. With me is Dr. Pramila Deck, Attorney Eugene Nigro, Attorney Gay Bell, Attorney Melissa Howitt, my mother Gail Salisbury, my daughter Ellie Salisbury, my son Brody Salisbury, and my wife Jody Salisbury.
Welcome.
I thank Chief Judge Casey for being here as well.
Good move, you're the only one that remember them. You'd be like wherever you want to be.
That's right.
But not Pittsfield?
From my house, prefer.
Be the assistant chief.
Thank you for that. Can you please introduce your first witness, please?
Sure. So I believe Judge Ricky is on Zoom if you want to do her first.
Sure, absolutely. Good afternoon, Judge,
Good afternoon.
and welcome to
Yes.
our hearing.
Thank you. Good afternoon, honorable counselors. Thank you for allowing me to testify remotely on behalf of Brian's judicial appointment. I'm appreciative of this opportunity to speak with you. It's always humbling for me to be in the State House and to appear before you. The very important and necessary work and deliberation that the Governor's Council do in approving judicial nominees ensures that all of the citizens of Massachusetts get the most exemplary and the most qualified judges that they need and that they deserve. As a former probate and family court judge, I personally thank you for your dedication and service to us. Every time that I have testified at the Governor's Council, I realize the importance of these confirmation hearings, your authority, your questions, and your concerns. These public hearings ensure that each judicial nominee meets the highest of standards and is carefully vetted. Please indulge me as I brag about the uniqueness and critical importance of our probate and family court, where I was privileged to serve and sit for over 21 years. Of course, all 7 trial court departments are important to our citizens, but no other trial court judges require the judicial temperament, the problem solving, and the demeanor that probate and family court judges must have and must retain on the bench. Every day, litigants are in pain, they're in fear, they're fighting addiction, they have mental health crisis and medical crises, and they flock to the probate and family court for the most important and the most personal decisions: custody of their children, their homes, financial support, mental and medical health treatments, etc. Their personal and continuing issues do not end when the probate and family court renders a decision. This is not the court where you go to get a dollar award or a business decision or a guilty or a not guilty decision. This is the court where the same family members, parents, ex-spouses, grandparents, children, guardians, must continue their lives together and must interact together as they live by the court's orders. These are the very reasons that your consideration of the probate and family court's appointees is so critical. Appearing today for Brian Salisbury is an honor and it's a pleasure. It's easy to speak favorably and enthusiastically about a nominee with his breadth of legal experience and his qualifications. It's equally important, though, that I address Brian's non-legal qualifications and his demeanor, problem-solving, temperament, and decision-making skills, because these are equally important to the litigants and lawyers who will appear before him. I expect that you've read my 2 letters of recommendation to the Judicial Nominating Committee, as well as Brian's application. Brian is an active and involved practitioner on both the probate law side and the family law side. Most judicial applicants specialize in either family law or probate law, but Brian has both. He has tried many family law cases in front of me, as well as complex probate matters. He's also mediated numerous divorce and probate cases with me since I have left the bench and begun my mediation practice. Brian has worked in respected and prestigious family law and probate law firms. He and his partners are leaders in the family and probate law world. Attorneys call upon Brian to mediate their cases, to arbitrate their cases, to serve as a discovery master, to serve as a parent coordinator, and to serve as a guardian ad litem. Judges appoint Brian to serve as a guardian ad litem, as a master, as a parent coordinator, as a guardian, as a conservator, all vital and necessary quasi-judicial roles that the probate judges require. Just by reviewing his court appointments, you should be ensured that Brian is respected by both the bench and the bar in their choosing him. Demeanor, patience, and respect are crucial qualities in probate and family court judges. The litigants are anxious and scared. Most courts have at least 50% self-represented litigants in their cases on both sides who do not know the rules of law or do not know the rules of court. Probate judge must stay patient and must stay focused in very highly emotional scenarios. Brian has always treated everyone, the judge, the court staff, opposing counsel, opposing party, and his own client with utmost respect, professionalism, and resourcefulness. I know he will do that every day on the bench. In closing, I emphasize Brian's litigation experience and expertise, his writing skills, but especially his exemplary demeanor. We would be well served to have him on our court and will be well served to have him on our court. I thank the Governor's Council for your thoughtful consideration of him, and I thank you for your service to the bench, to the bar, and to all the citizens of Massachusetts. Thank you.
Does any counselors have any question?
No, thank you, Judge.
Thank you.
Certainly welcome.
Brian, can you introduce your second witness?
Sure. Dr. Pamela Deck.
May I proceed?
Absolutely.
Good afternoon. Thank you for having me today. It's an honor and a privilege to be here to speak on behalf of Attorney Brian Salisbury. My name is Pamela Deck. I'm an attorney in good standing in Massachusetts. I'm also a licensed independent clinical social worker, and I also hold a doctorate in social work where my studies focus on child and family forensics, which is particularly important in this area of family law. I first met Attorney Salisbury about 7 years ago on my first ever divorce case. And it was a little rocky for me. I was fumbling my way through, and Attorney Salisbury was just the height of collegiality. He really towed the line between advocating for his client and also helping a fellow colleague. There were gentle nods, hey, it's your turn to speak. There were gentle pushes, hey, we got to file this motion. And at all times was I treated with respect. And that helps me to understand that were he to be on the bench, he would treat everybody in front of him with respect. Those who know what they are doing and those like me who really didn't at that time. And as Judge Rickey just testified, we have about 15% who are pro se litigants. He will treat those people with respect. No fault to Attorney Salisbury. I decided I really do not like litigating. So now I lead with my mental health degree. I define myself as a forensic mental health practitioner. All of the work that I do is in the probate and family court, but I'm more on the preventative side now. I do a lot of, alternative dispute resolutions. So my work is child custody evaluations, parent coordination, mediation, court-involved therapy. Not surprisingly, I find Attorney Salisbury in those spaces as well. And what that tells me is that not only does he have an excellent grasp of the law, but he also has an excellent grasp of reality, that these cases are about families, and they're hurting. And he knows creative solutions, other resources that are out there, other than the adversarial court setting, to help these families move on and repair. The other arena that I see Attorney Salisbury often is in conferences. And what that tells me is that he's humble and he's looking to better himself and extend his knowledge. So when I think of him, I think of somebody who's collegial, somebody who's creative and willing to learn more, and somebody who's humble. Judge Ricciardi spoke to his temperament, his demeanor. It's what belongs on the bench. And when I think about our bench, I would really be proud to have Attorney Salisbury on there. Thank you for letting me speak on his behalf today.
Thank you.
Thank you so much.
Any counselors, any questions?
Just a comment. I really appreciate your testimony.
No question.
Thank you.
I do have a comment. So I really do appreciate your testimony and your unique, multiple pronged perspective on it. We don't often get to hear from someone who has all of those areas of expertise kind of coalescing into one. And so I really appreciate you coming today and I appreciate everything.
Thank you, I appreciate that.
Thank you. And is there any opposition?
There were a lot of people waiting outside.
And I also would like to thank my counselors. We have Counselor Ferreira, Counselor Ziegler, who's on Zoom with us this afternoon, Counselor Kennedy, Counselor DiPaolo, Counselor Tara Jacobs, Counselor Ferreira, and Counselor Dolan. And I want to thank them for being here today, and we'll listen to you to make a decision on your behalf. And I will give you the floor.
Thank you, I appreciate it, and I was impressed by Promola's statement to you that she didn't have any notes, but I don't have that skill. I'll read my statement. Good afternoon, Madam Chairperson and distinguished members of the Governor's Council. I'd like to begin by expressing my sincere gratitude to Governor Healy and Lieutenant Governor Driscoll for the tremendous and humbling honor of being nominated to serve on the Probate and Family Court. I would also like to thank the members of the Judicial Nominating Commission, Chief Legal Counsel Paige Scott Reed, Deputy Legal Counsel Derek Kesselheim, Administrative Secretary Valerie McCarthy, and Legal Program Coordinator Kimberly Baptiste for their support and guidance throughout this process. I would also like to extend a special thank you to Dr. Deck and Judge Ricky for graciously speaking on my behalf, and to all of my friends and colleagues in attendance today. And of course, I'd like to thank my family, whose unconditional love and support have made this day
It's okay, take your time.
and every other day possible.
What about those Red Sox?
You're gonna cry on the bench.
Finally, I want to express my appreciation to each of you for your important work that you do on behalf of the Commonwealth and for the time and consideration you've afforded me throughout this process. This is another tricky part. Excuse me. I was born and raised in Attleboro, Massachusetts. My parents were divorced when I was young, and I lived with my mother and sister. Growing up, despite her best efforts, my mother did not quite earn enough money .
Okay, take your time.
Oh, we're good. You're only showing your real. Don't worry about it. You're showing your real. It's a good.
I think that's the most honest hearing you can possibly.
Doesn't the chief matter about too? Can I just? I said something going on here, yeah. I think something's going on here, but go ahead.
This is gonna be the sample we're gonna use to put up, we'll show what it's like, you gotta show you.
I appreciate it.
I'm sure your kids are used to this.
Yeah. Didn't earn quite enough money to get by, but too much money to qualify for public assistance. Oh, boy. She worked tirelessly, often holding 2 or even 3 jobs at a time. I'm not usually like this. Every morning without complaint or fanfare. She got out of bed, still tired from the day before, and headed back into the world to support her family. In those quiet moments of sacrifice, she taught my sister and I the importance of responsibility, hard work, and family. These formative experiences have shaped my perspective on family and made me sensitive to the struggles families face. I attended the University of Massachusetts at Amherst as a business major, and I was a member of the marching band where I met my wife, Jody. After college, I held various positions in the finance industry, but in 2002, I made the decision to attend law school. I enrolled in the evening program at Suffolk University, where I worked full-time while attending school. I graduated in 2006 and started a new career as an attorney. It wasn't too long into my new career before I realized that my business background was a useful tool in matters before the probate and family court. It provided me with an opportunity to take on complex financial issues, both in domestic and probate matters. In 2008, Jody and I married, and we chose to settle in Bellingham, Massachusetts, where the homes were affordable, and it was somewhat located halfway between my job in Brockton at the time and her job as an 8th grade science teacher in Weston. In 2009, our daughter Ellie was born, and our son Brody followed in 2011. So this is going to be an ironic statement after the beginning of my speech. Most, if not all, of the people who know me personally or have worked with me professionally would likely describe me as calm and even keeled, even in the face of strong emotions. I believe this is a trait that will serve me well as a judge. Sometimes when emotions are running high, which they often do in the probate and family court, someone who can maintain a calm presence can help diffuse tense situations that might otherwise escalate and derail hearings. I believe deeply in giving back to my community. For approximately 14 years, I have served on both the planning board and zoning board in Bellingham, as well as various other ad hoc committees as they are needed. I'm also a member of the Bellingham's Lions Club and the Bellingham Friends of Music. In 2019, I started the Ask the Lawyer program in collaboration with the Bellingham Public Library, where I meet with community members each month to answer their legal questions. Professionally, I've followed a similar path, becoming more involved in the probate and family court as my career evolved. As Judge Ricky had mentioned, I became a Category F guardian ad litem, appointed in custody matters to investigate the facts and circumstances of a particular family and to make recommendations to the court regarding an appropriate parenting plan and custody arrangement. I also serve as a parent coordinator, working with parents to resolve child-related issues in a timely and productive manner. Additionally, I became a Category D guardian ad litem in probate matters, representing minors and incapacitated individuals. Lastly, I've served as a discovery master and a special master to oversee the sale of real estate. If given the opportunity, I look forward to continuing to serve our community and our court in a new capacity as an associate justice. I thank you for your time and consideration.
Thank you. Brian, I want to let you know that you're in a safe place. Cry as much as you can, if you have to. We're in a society where it states that men don't cry. And I believe that our constituents want to know that we're putting real people on the bench that has gone through real issues, that understands that when they go before them, they will understand what they've been through and that someone is going to be listening to them. So I want you to take your time, answer the questions as much as you can, but most importantly, know that you're in a safe place and that you deserve to be here.
Appreciate that.
Okay? So we will start off with Councilor Ferreira because he doesn't have a question.
Thank you.
You're welcome.
We had a great conversation. I've got a lot of great calls about you. Being a father of 3 daughters, I cried too. The worst I wanted to cry was 20-some years ago when I got divorced, and I had a horrible judge in the case, and we've talked about that in length, who didn't want to give dad 50% physical custody. I finally got it, and it's worked out tremendously. They're now 26, 30, 33. I have the best relationship any dad could ever have with their daughters, and I encourage, like, whenever possible, to make sure that all mom and dad both have physical custody of their children, and I'm a big advocate of that. I'm glad to make a difference in that today. But now I cry tears of happiness when my kids are so successful and do well, so it's okay to cry. But I think you got to make a tremendous judge. You have great temperament. You have a great personality, and you have a great reputation in the community. And I love that you bring that empathy and compassion to the bench, and that you're going to give everybody a right to be heard and a fair shot. So I'm looking forward to voting for you, and I thank you for applying. Thank you.
Thank you. Councilor Dolan.
Thank you, Attorney Salisbury. That was really beautiful. And I'm glad to know how much you love your family, because that's what that seemed to me that was about. So this is going to sound so dry now. One of the wonderful things about your qualifications is that you, in addition to having family law experience, you also have probate experience. And I wanted to ask you about conservatorships, because I know that they are supposed to do an accounting, but I also understand that doesn't always take place. And I'm wondering what you would do as a judge to make sure that conservatorships have the accountings that they should have.
So I know at least in Suffolk probate that they have a system where they will, if they don't, a particular system where if they don't receive an account, that they'll notice a hearing and require the conservator to appear, and if they don't appear or don't file an account by the time of they'll be dismissed as conservator. But I think that's a good system, just staying on top of that and having the administrative resources to make sure that that system is in place and somebody stays on top of that.
And I just want to ask you one other quick question, as I know Councilor Civil really supports your nomination, and that means a lot to me. One of the things that I was really interested in was that you talked when you spoke, and I thank you for coming out to Concord to meet with me. You said that you had taught high conflict parenting classes, and that one of the things that you taught was de-escalation. And I think de-escalation is something that we need more of in society at large. And there certainly are times in court when I think judges do need to de-escalate. Can you talk about the de-escalation techniques that you would use as a judge and when you might use them?
So I think that a good judge, an effective judge, leads by example in the way that they maintain the courtroom, how they speak to people, how they deal with people, and the things that they prioritize. So I think being calm and being thoughtful and kind goes a long way in de-escalating anything, but then also recognizing that people that have suffered trauma in the past, or just they haven't suffered trauma, but they're in the probate and family court and it's an issue about their family, that everyone is sort of on a heightened emotional plane, just recognizing things that you can do to make the court process a little bit easier for them and not trigger past traumas and things like that.
Thank you. I'm very confident you have the qualities and qualifications that you need. Thank you so much.
Thank you, I appreciate it.
Thank you, Counselor Dolan. Counselor Ziegler?
Thank you, Council Chair. Attorney Salisbury, thank you so much for being here and for putting your candidacy forward for this role. I truly do appreciate the time that you took to speak with me prior to this hearing to review your candidacy and to discuss why this role is so important to you, why the courts are so important to you as well. We talked a little bit about your experience, and I appreciated, reading through your packet and also looking at the fact that, you see this role as a community-facing role, and you have experience in community, having served or currently serving on the planning and the zoning board in your local community. I find that to be a key skill. We talked about your priorities as well, should your appointment be confirmed for the bench. And I'd love to give you an opportunity to speak a little bit more about that in this forum. So can you speak to your priorities as a judge should you be confirmed?
Sure, so I think that something that I could do almost right away is to address what I think is everyone recognizes as a problem in the probate and family court is the civility that's amongst attorneys that practice in that court. And I think something that I could do is to treat people civilly and to treat people respectfully and not to layer in emotion on top of the motion that has brought people to the court. Also, as a judge, not tolerating incivility in the courtroom as well, not allowing people to speak over each other or to call somebody a liar, other inflammatory terms like that. I think that's something I can do almost immediately.
I appreciate that. As a judge, what type of environment would you be looking to create in the courtroom for litigants?
So I think it's incumbent on any judge to recognize that nobody ever wants to be in court. And what brings them there is something not good, generally speaking. And those people aren't familiar with where to go and where to stand and what to say and who to talk to and all the terms that that lawyers and judges use, and to be mindful of all of those things in making the courtroom welcome. And like I said before, being respectful and kind and aware of the different kind of people that are before you, where they're coming from, and just seeing the big picture.
Thank you. What would you say is the greatest strength that you bring to this role?
I'm sorry, the biggest?
The biggest strength.
Buying dinner tonight.
I'm sorry.
Strength.
Greatest strength. I would like to think that my biggest strength would be temperament, perhaps. If I had an innate, something innate within me that makes me suited for this position, I would think with temperament, I would think a close second would be just breadth of experience. There's people that have been doing it longer than I have. That people are smarter than me for sure. But I'm relatively unique that a lot of practitioners only work on one side of the house of the probate and family court. And I've had the opportunity to work on both.
Thank you. I definitely appreciate that. And I'm glad that you highlighted that. That was one of the things we did talk about in length about your experience on both sides of the court and how crucial that is. And that's not something we always see before us in the Governor's Council. So I do appreciate that experience. And I also appreciate you being intentional about the way that you answered questions and being open, allowing me and my colleagues to be able to really get to know you as a candidate. So thank you so much for your time. And with that, I have no further questions.
I appreciate it.
Thank you, Counselor Ziegler. Counselor Kennedy?
I'm in my 15th year on the council. And that was the most powerful opening statement I ever heard, because it really showed who you are. And showed that you would, your humanity. I just want to say to your family that they should be very, very proud of you. You know, it's a great accomplishment to be sitting here, period. Very, very few lawyers. We have hundreds and hundreds of thousands of lawyers in Massachusetts. And I did the math one time, and I think it was something like 0.02% of the lawyers get to become judges. You got a better chance of getting in the Harvard. Not that I ever had a chance. But be proud. That opening statement was really powerful because of the emotion you showed. And that means a lot, because it tells us how you're going to be on the bench. A lot of people sit up there and tell us what they think we want to hear. You didn't do that. You just came across as you. And that means a lot. You cheated by bringing Eugene Nigro with you, because he's somebody I've known and admired for 4 decades. He's a legend, as you know, in the legal profession. So I wouldn't have any choice as soon as he showed up but to vote for you. But I do have one question. You mentioned the opening. I had already saw it. I was already going to question you about it. Tell me about the Bellingham Friends of Music.
So my wife and I we met in college in the marching band, so we're band people. If you know what that means. And then both of my kids started instruments. My son tried a trumpet. He didn't like it. But my daughter plays the saxophone, and she stayed with it, and she's in the high school band now. So it's a support group for that organization.
Well, when my daughter started at Boston College, she's still in a choir. She's in the Polymnius Society in Melrose. When she started college at BC, she said she was going to be a music major. And I looked at her and I said, "That's great. What major am I paying for?" She's a lawyer now. I'm sorry to say. You're terrific, and I'm going to vote for you.
Thank you. I appreciate that.
The family should be very, very proud of you today.
Thank you.
It's a great accomplishment.
Thank you, Counselor Kennedy. Counselor Jacobs?
Good to see you.
You can.
I don't have a ton of questions for you today. You mentioned in the room that it's great, the experience you have that does straddle both sides of probate and family court. I just want to expand on that by giving you an opportunity. It's always great to know what we don't know.
Yeah.
Knowledge where we have growth opportunities. Wanted to give you an opportunity to think about and share with us if there are areas where you recognize you may have a learning curve and what those areas might be, and then what's your process when there are areas that you don't feel quite as fully expert on. How do you inform yourself, seek information, or what's your process?
Yeah, so I'm very aware that it's important to know that what you don't know, and there's a lot about probate is a very complicated thing. Divorce is a very complicated thing. So I am very aware that each of those categories is something that it's a continuing curve to learn. I know that I've never done an adoption, so I've never participated in that process, so I don't know much about that. I've never been part of a petition for a do not resuscitate, those kinds of heavy things that I would need to learn. What I've done in the past, I started out working in a law firm in Brockton, worked there for 7 years, and then moved to Prince LaBelle in Boston, which is a bigger law firm, and they cater to clients that have more means than what I was used to working for in Brockton. And I don't know anything about alimony. when I got there because the clients I had didn't pay alimony. So I spent a lot of time on the train driving to and coming back from Boston, educating myself on alimony and sort of higher net worth asset divisions, complicated compensation structures, things like that. So I tried to fit in where I could to learn about things like that. So I would continue to do that.
I appreciate that. I don't have any further questions for tonight. Thanks.
Thank you.
Thank you, Counselor Jacobs. Brian, thank you so much. And I do have one question for you, which will tie up with you being your future probate family judge, because I think you have a plethora of experiences, but I think if we can elaborate a little bit more on one particular experience that you have. But first, I wanted to tell you that State Representative Jeffrey Roy spoke highly of you, and I do not take that for granted. He is a special friend of mine, so I just wanted to let you know that. And if you can expand on the guardian ad litem, what that is and your experience working that role.
Yep. So that it changes depending on the context in which it was used and what kind of case that you're on, but sort of in the domestic world, guardian ad litem is appointed by the court to investigate the a custody issue that's occurring between the parties, and that person will go out and talk with the parties. They'll talk with professionals involved with the families, the schools, pediatricians. They might review police records and DCF records, things like that, and then at the end of it all would speak to the kids and sort of get a privileged look into this family, what's going on, and then you're able to, or sometimes the court asks you to make recommendations about parenting and custody issues. And then similar roles in the probate world where sometimes there might be an heir who is a minor or is disabled, or there might be an account that needs to, someone's filed an account, but someone needs to review it for the court and agree or assent to it to make sure it's done properly. So that's what a guardian ad litem would do on the probate side of the house.
Thank you. And I lied, I have one more. Can you talk about Ask a Lawyer program? Talk a little bit about that, something that you do?
Yeah. So I started it before COVID, and COVID kind of killed it for a little while. I would, before COVID, I would actually go to the library and meet people in a study room. And then COVID happened, and then, I don't know, within the last year or two, I brought it back. But the library maintains a calendar. People can sign up. It's supposed to be 20 minutes, usually turns into 30-minute meetings, and I meet with them through Zoom. It's one night a week. It's a lot of, and it's rarely not, I don't say I'm a family law attorney or anything like that. I just ask the lawyer. But more often than not, it's people asking about things in the probate and family court, and it tells me that it affects the issues that come to the probate and family court affects a lot of people everywhere, and those issues are very common, and the people I speak to through that program don't have the resources to retain an attorney, so they're very grateful.
And what was your motivation behind that program?
I was, it's part of my wife says I'm a avid joiner. I like to do things, so I just did it.
Okay, well, your wife is always right. Happy wife, happy life. So I just want to say thank you for coming in today with your family and friends. And again, you deserve to be here because it was very authentic. Sometimes people tell you what you want to hear, but I think you demonstrated humility in so many ways. So I thank you, and the hearing is adjourned.
Thank you.